Yes.
Annexure 5, my lord. At page 49. And two clause of the RFB relied upon, where the RFB provides that the payment shall be made through online. Last occasion, Lordship, my Lord and Senior has. That is, my Lord, a relevant page. Just to recapitulate that provision, Lordship may find at page
Sir, I failed to
page
understand.
52. Page 52.
You will argue or he will argue?
I have filed my reply affidavit.
Counter they have filed. Counter they have filed. I am filing the rejoinder, my lord. If not to hear the matter, I am also ready.
No, but you shall have to give the rejoinder.
Yes, my lord.
Give it.
Survey copy.
Give
So
it here.
the matter
But-
is of public importance, my lord.
That is exactly
Why
I
I-
want, my lord.
Lord,
Tomorrow or Monday, any day, you may hear the matter.
See the rejoinder.
Lordship,
Have you seen the rejoinder?
may I take up, may I submit, my lord, the matter may be taken up, since it has not been admitted. And the last occasion, Lordship directed, you file your reply, I have filed my reply. So only two provision of
So
the.
now he has filed the rejoinder.
Man.
So do you want to see the rejoinder?
Yes, my lord.
See the rejoinder, come on Monday.
Okay.
All right.
Right.
A counter affidavit has been filed on behalf of the opposite parties, to which a rejoinder has also been filed on behalf of the petitioners. So place this matter on Monday, retaining its position. So as to enable learned counsel for the opposite parties to consider the said rejoinder. Yes, sir.
So appearing here for one of the persons who has successfully qualified.
Opposite party number 5.
It will retain its position.
But the interim order to continue. Interim order.
Interim order, what? Interim order
So
is
subject to result.
No, no,
It
interim
is
order,
subject
whatever
to
you-
No.
result of the.
Extent.
On his statement that only financial technical bid was open, but
Price
financial
has not
bid
been opened. My case is, entire case is, my finance bill should also be open.
We will see.
Item number 2.
Vendor may be given to us.
Right. Counter order, we have not appealed.
Give him a copy.
Sir, counter, I don't know.
We have not yet filed counter. But
In the,
we
just,
will be able to
in the
assist the
meanwhile,
court.
it is expected that in the meanwhile, the parties shall
I'll serve a copy.
exchange their pleading.
Rejoinder copy would be.
We are all grateful.
What is the provision under the rules?
Sir, unless they appear, the appearance is accepted, question of serving copy doesn't arise.
We have appeared. File Wakalas.
If they appear, I definitely I'll serve.
they have appeared. Yeah. He has filed his memo.
But he said I'm
Being
going to
engaged.
appear on behalf of- Therefore, I said, you appear first.
Item
His
number 2.
name has already come on the cause list also.
Sir,
His name has already come on the cause list.
May I plead your document? The writ appeal, my lord, challenged against the judgment of the honorable single judge, wherein he came to the finding that even though the writ case was restored, it will not relegate to the same position when it was dismissed. So the position is that when the case is restored, it has to be relegated to the position when it was dismissed.
Where is that order?
That order at Annexure 1, Lordship may come to the finding at page 25, the relevant portion of the order. After hearing the learned counsel, may I read?
Yes.
After hearing learned counsel for the parties on the preliminary point, this court is also of the view that under the peculiar fact and circumstances referred to in proceedings,
To page?
page 25, running page 25,
Yes.
paragraph 7 of the judgment. Peculiar fact and circumstances referred, paragraph 7. Referred to in the proceeding paragraph, it cannot be said that the order of this court had been deliberately violated on the violated. On the contrary, there being no prohibited order in operation at the relevant time, as a consequence of dismissal of the writ petition, the petitioner was called upon to join in this duty as per the modified order after the approval. Mr. So-and-so, counsel, since once the service of the petitioner had been approved against a particular post, the same cannot be subsequently modified, and that too with retrospective effect. He further submits that the opposite party number 6 had never challenged the original order of approval, whereby the petitioner was approved against the second post. This was my contention. Then, next page, in response, Mr. So-and-so argued that an employee cannot claim any vested right to a particular post. As per order of the government, the school was entitled to 3 peons, one office peon, one science attendant, and one night watchman cum sweeper. It is obvious that the posts are to be filled up on the basis of seniority of the employees. There is no such rule, madam. Here, he came to a finding that on the basis of seniority, appointments shall be made. It is not the rule. Whenever the managing committee found it necessary, it can appoint the person to the suitable post. Here, the seniority doesn't arise, nowhere it is prescribed. He has come to the finding that night watchman, so it is obvious that posts are to be filled up on the basis of seniority of the employees. It is not disputed that Gayadhar Nayak, means OP number 6, is senior to the petitioner.
You started with some submission which is different from what you are referring to. You said that your writ petition was dismissed
Dismissed in 2017.
in 2017.
17.
And when did you file your restoration application?
Restoration, my lord, it was restored in 2019.
2019.
19.
When did you file your restoration application?
Restoration application. That is not there, but the date on 10/1/2019, your lordship may see, must be in 18, my lord. 10/1/2019, in WPC 18128. That's a part of the record, my lord. There it was restored. From the date that it
Yes.
was restored.
Yes.
So when it was restored, my lord, thereafter the order was passed again, really, saying that no, I am not entitled for the post in which I have appointed and worked for 9 years. I was appointed against a post recommended by the managing committee of the school.
Why did you make this submission that learned single judge has
Yes,
taken a
no,
view
yes,
that after restoration,
Yes.
the entire, the orders passed in the earlier case do not revive?
yes,
Is this your submission?
yes, yes. That is one part of the
So
submission.
why did you make this submission? On what context?
I say, my lord, had the position have been delegated to the same, this order could not have been passed because there was an interim order saying that the modification of my change of my post shall not be given effect to by an interim order in the writ petition.
Just a minute. So what was the interim order?
Interim order. Uh, 15/2/2010, my lord. The interim order
2010, the interim order was passed.
passed.
5/2/2010.
This is miscase number, yes.
It
Miscase,
is not 15/2. It is 5/2.
sorry. Maybe,
5/15/2010, the interim order was passed.
Passed, madam.
No,
This is in miscase number 1552.
5/2/2010,
5/2, interim order was passed.
the interim order was passed.
Passed, madam.
And then it was dismissed.
It was dismissed because there was some communication gap for non-prosecution.
Just
It was,
a
yes,
minute.
my lord. It was dismissed in
It was
2017,
dismissed in 2017.
my lord, the 11/7/2017.
So what happened to the interim order after dismissal?
My lord, it goes, my lord,
It goes.
goes.
So
Not-
if the interim order goes,
Yes.
then something could have been done.
My lord, thereafter, I filed the restoration petition in
Restoration you filed in 2018.
18.
So according to you, the interim order should have continued till you file your restoration application.
No, after the restoration petition was allowed, my lord,
We understand that.
my,
If what you are submitting is
Mine.
to be accepted, then the authorities could have waited till you file your restoration application and restoration
not
application.
that, my lord, exactly. Because the litigation was pending in between the parties, my lord. So there would not have,
Litigation was not pending when your writ petition was dismissed for default.
my lord, that was dismissed for default, my lord, but
Yes.
my lord. And the second,
Yes, if that is your submission.
that
then
is
there
one point, my lord.
There is no merit.
And the second contention, my lord, that the court said that because there is some mistake in the approval, order of approval by the
Let
government,
us understand the fact.
my lord,
Which post, you are fighting against which post?
my lord, I am working as a peon in the night watchman cum sweeper. I was appointed against the second post, my lord.
Second post where?
Second post of the, my appointment order is at running page, my lord, 54.
Where were you appointed?
Appointed in the school, my lord, by the managing
Which school?
committee. Yes, high school. It is aided high school.
When?
In 2001.
Then what happened? What is your grievance?
Yes, I continued to work till the school got granted, my lord. Thereafter,
So when the school got granted?
2008, my lord, they approved
Yes.
with effect from 1/4/2008, my lord. That was page 55.
Then
Yes, thereafter, my lord, what they did, they arbitrarily passed one order modifying my position. I was given another post and the person working against the other post, he came to my place. There was no notice to me. There was no information.
when?
Look, that was Annexure 3. That was passed in 2009, 13/10/2009.
Yes.
At page 57, my lord.
Yes.
I challenge that. And interim order, as I have stated, my lord, interim order was passed that this order of modification shall not be given effect to, my lord. In the meantime, because of some communication gap, it was dismissed in 2017. I filed an application for restoration. Coming to know that these are dismissed, I filed an application for restoration. It was restored. And thereafter, my lord, they could not change the position. They say that the order of modification of the interchange by post, that is valid. Therefore, I approached this honorable court again. Now, this honorable court came to the finding that if there is a mistake on the part of the government and the modification order was somehow passed, or the approval order was passed, showing me as in the second post, it is subjected to correction at any time. My humble submission is that is not a mistake. Here, because it is a private aided school, the managing committee is the sole authority to appoint under the rules. Now, they have given appointment. It was rightly approved. And after 8 years, it cannot be arbitrarily changed. It is not a mistake. Rightly, they have approved my post. And I was continuing in the second post. So, it cannot automatically change. The learned single judge came to the finding that on the basis of seniority, since admittedly OP number 6 is senior to me and was given appointment prior to me, he should have hold the post of second. That is the finding. But there is no such rules that the senior in age, senior in appointments are hold a particular post. On the basis of seniority, appointment cannot be made. That is what my humble concern. These are the two points on which
I think there is some one honorable Supreme Court judgment is there. On the basis of seniority, Pune 1, 2, 3. the first peon will go to Daftari, and the second peon will be first peon, and third peon will be second peon.
On the basis of seniority.
Rajendra or
With
something.
Rajendra Kumar Das case, in that case, that the concept of fourth peon was not
Maybe
there.
different context,
That
but their
regarding that
observation of
concept-
Honorable Supreme
regarding that
Court is
concept of fourth peon. So Honorable Supreme Court said that there is no concept of fourth peon.
fourth peon.
The first senior most will go to the post of Daftari. Thereafter,
The fourth
Three
peon
posts-
will be adjusted in a third.
then
peon.
three posts shall be admissible.
That is the manner of arrangement in respect of peons.
On the basis
I
of
think
seniority.
that judgment still holds.
Yes,
true.
sir.
Aided institutions.
Yes, where is that judgment?
Judgment, my lord, that seniority shall be counted, my lord. I don't find, my learned friend may say on the basis of seniority, appointment shall be made. Here, appointment has already been made when there was no other post like second, third, and fourth, my lord. Lordship may, for a moment, turn to page.
So do you get more pay? What prejudice does it cause?
Because I was posted, I have been working as a science attendant in the school. my lord. Now they post me as a night watchman cum sweeper. I was never appointed in that post. My post was never approved in the never approved as a sweeper, watchman cum sweeper. That is what the was, nothing else. my lord. And the person who was appointed as night watchman cum sweeper, he never complained. He also worked for 8 to 9 years. But they modified arbitrarily by interchanging the post, saying that your post has been modified so and so and so. So motto. Can the DEO pass such an order when the managing committee is the authority to give appointment? Can the approval be something else than the recommendation of the managing committee? No, that is the question. They cannot.
May
And,
I draw your attention to your writ petition annexure 2. Where the school has been granted aid, block grant, with effect from 1/4/2008,
Yes.
as per prescribed yardstick. And perhaps in the serial number 4, your name appears.
Which page, which annexure? Annexure. Uh-huh.
One 18128.
That is at page 40 of that writ appeal.
Page 40.
My lord, page 40.
You have that
That page 40 of that writ appeal, my lord.
writ petition.
He has annexed that writ petition, my lord. At annexure 1. Sorry. This is at annexure 2. Page, it starts from page 30.
Page?
30, my lord. The writ petition that has been annexed. here.
No, I am at
Your lordship is looking at order dated
yes,
2011
40,
2008.
40.
Page 40, that is at page 40. Yes, ma'am.
This
Let's
is
see.
office of the inspector of school,
Yes, ma'am.
Balasore.
Yes, ma'am.
Yes.
That serial number 4 is the appellant.
Yes.
So
There it is stated
that,
that it's not admissible.
that paragraph starts the staff member whose appointment have not been approved due to reasons noted
Yes, ma'am.
against each are mentioned hereunder.
Purushottam Swai,
Huh.
the petitioner.
Peon, then
Not admissible, perhaps that is written as not.
Admissible.
Not admissible, because it is not legible.
No, Purushottam Swami peon not admissible.
And the very next page, the approved staff list. Page 41.
That was the illegality committed by them.
Yes,
That they
no, they
subsequently
approved.
approved.
Me and OP number 6, they approved. But OP number against OP number 6, they say.
No, next page,
Yes.
serial number 12,
See- see
last column it is cross.
Yes.
Purushottam so and so
That is crossed.
crossed. But in so and so
All others are approved,
approved.
except serial number 4, 5 and 12.
Yes.
4, 5, 6 and 12.
11.
Whose
11
name appears at
see,
page
11.
40.
Serial number 11, class 10, watchman, come sweeper. So in that post, OP number 6 was approved. And my approval came a lot. That is at page number. Page number 2A, page number 55. My approval. My
Of the
appointment
appeal.
is page number 54 and my approval is page number 55
Of the writ appeal.
of the writ, running page. Writ appeal. Pursuant to the government letter that so and so, Department of School and Mass Education, so and so, services of the Purushottam Swami peon, so and so high school, it is hereby approved with effect on 1/4/2008 in the scale of pay so and so, in the revised scale of pay so and so. This is my approval. In the very next page, 56, I have given the list of the approved staffs with their designations.
Yes.
And thereafter, they modified at page 57, Milord. That is what I was aggrieved. Page 57 of the writ appeal. Pursuant to the government notification that is so and so 8/12/2008, District Secondary Education Orissa, Bhubaneswar, letter number so and so, the services of Sri Vadha Nagarati OP number 6, peon, who was approved as night watcher cum sweeper by this office order number so and so, with effect from so and so, was services of the peon who was approved, and the services of Purushottam Swami peon who was approved as peon is hereby
Modified.
and approved as night watcher cum sweeper. So it was post was interchanged. This order he could not have been passed. Under what authority of law he has changed this order, it is not known. And they say because of the government notification that is 8/12/2008. Now government notification 8/12/2008 is at page number 75. It doesn't say that the post will change. In a post I am working for last 9 years. How can it be changed?
So the post is not
Yes,
interchangeable.
it cannot be changed because managing committee has appointed me. It was approved. The post was approved in respect
So
of
there are different posts, peon,
Yes,
night
yes,
watchman.
and
there-
science attendant. So and so. I claim second post, that is science attendant. And he was working as night watcher. Because of some other reason, this was changed. And never I was never
In 2009, in 2009, when your post was
Yes,
approved,
yes.
was
Thereafter it was post
when-
after approval of
please.
the post, it was changed.
please, 2009, when your post was approved,
Yes.
that was approved in the post of peon, not science attendant.
Science attendant, but
It is not science
it
attendant,
was peon.
as you claim.
Yes, yes.
As you claim, science attendant, but it was not approved as science
Science
attendant,
attendant.
but
Yes,
it is approved as peon.
peon,
But later on, they have
interchange.
changed it to sweeper come night work.
Night watchman from sweeper.
Night
And-
work.
And the person who was working against that, he was brought to science attendant. My appointment was against the second post, that is science attendant.
Perhaps that
Second
is,
post of what?
Second post of peon. There are 3 admissible posts of peon allowed in a school.
So we are,
Office peon.
therefore, we are, see, if there are posts of peon, 3 peons with same scale. It's only question
Right.
of, it's only question of assigning duties.
My lord, that's, yes, we all are peon. OP number 6 is peon, me is peon, and the office peon is there, is senior to us, there is no dispute about that. It's only assignment of duties, my lord.
Assignment of duty, how can you question?
My lord, assignment of duty in a particular post, my lord. If that is not questioned, how could they change, my lord? Can
There
they
will be
modify?
question of assignment of duty can be changed.
My lord, here, my
See,
lord,
you, whether you were appointed as
fine settlement, a second,
No, forget science. You are appointed against a post of peon.
second, yes.
You are
Managing committee
appointed
appointing is
against a
second
post
post,
of
second
peon.
peon.
Just a minute. You are appointed against a post of peon.
Peon, yes,
Was there any post of night guard or watchman?
yes. Yes, under the peon headings, your lordship may see page 75. Page 70. He appointed in 88, my lord.
Six, when, was it, respondent number 6 was appointed?
He was appointed, my lord, on 28 to 1988, my lord.
28,
Page 77 is the appointment order. It was in 88, my lord. Much before me. Still no doubt about that. 1988, my lord.
and you were appointed on?
2001, my lord, in 2001.
And he was appointed against which post?
He was appointed the 4th peon. Because that was the necessity of the school might be, so managing committee appointed in 4th peon.
Because he was appointed as 4th peon and you were appointed later, therefore,
Second peon. So there is no, if on the facing the necessity of the school, they can appoint. There is no such that they will appoint the first peon first, second peon according to them again, second peon serially.
Now I have been possibly able to understand.
Good judgment.
Yes.
And lordship, for a moment, lordship may come to A by
Okay.
3, page 75, where there was no
Mr.
other
Counsel,
post.
according to you, respondent
Yes.
number 6, who was appointed in
80,
1988,
yes,
was appointed against 4th post.
4th peon,
And you, 4th peon,
yes,
and you were appointed in 2001 against 2nd peon.
second peon,
Sorry.
second peon. Here,
After 1 week.
by saying that here, there are no other. One thing I want to know, your lordship may see page 73.
Yes.
There was no other post except peon and sweeper. Therefore, he was appointed, OP number 6 was appointed against the post of sweeper.
And what happened?
And thereafter, my lord, posts were created.
What
by next
happened
page.
to the disciplinary proceeding pending against you?
No, it was, I was reinstated in school, that goes below.
That
I was
goes,
reinstated in school.
or your suspension has been
Yes,
withdrawn.
I was reinstated.
Disciplinary proceeding is still there.
But, I don't think- After my reinstatement, there is no other case.
Was there any criminal case lodged against you?
No, that was acquitted. That was because of some rivalities, some complaints are made, that's not related to
All right, we will decide.
mine.
2 weeks. Fine.
Item number 3.
Yes, my lord. In this case, I am for the appellant, my lord. Here the appellant challenges the order dated, my lord, 13/3/2024, passed by the Honorable Single Judge Bench.
Yes.
My lord, the appellant who is one of the contesting candidate for the post of a chairman in Sundargarh Municipality, the election was held on 24th March 2022. Thereafter, my lord, appellant contested the election as an independent candidate. And respondent number 1 and 2 contested.
No, which election?
It's a municipality election, my lord.
Oh, which
ULB election, urban local body election, my lord.
Which year?
2022, my lord.
Yes.
My lord, respondent number 1 represented himself as a through BJP, Bharatiya Janata Party, and respondent number 1 represented as
So
Bharatiya
under
Janata
which
Party.
provision of law this writ
My
petition
lord,
was entertained?
My lord, section 19 of Municipality Act, the application has been filed by the appellant because he's a defeated candidate and she identified some manipulation.
Counsel,
And
you filed a writ petition.
yeah, I didn't file the writ petition. My lord, 711 application has been filed by the respondent at the time of the trial, when my entire cross examination has been over, and when his part is started, at that time he filed a 711
So
application.
we are trying to understand
My lord.
as to whether the order which you have challenged
Yes, my
was passed in exercise of which power?
226, my lord.
How 226? Was an order against an order passed by a court.
That is respondent number 1 has challenged, my lord.
So what?
711
So what? That
application
cannot be
order.
cannot be entertained.
Under 226 and 227, the writ application has been filed, my lord.
Your file 226.
Yes.
But whether under 226 the writ petition could have been entertained, has been entertained under 227.
Order that I didn't file the writ application, my lord.
So what? You cannot challenge, you cannot file writ appeal. You can file anything, but not writ appeal. The appellant in the present appeal.
If
has
your lordship
put to-
permits, then I will change the nomenclature and
You cannot change the nomenclature.
okay.
You'll have to go to some higher forum.
Yogendra Singh ji,
My
Supreme Court,
Supreme Court.
judicial orders cannot be challenged in writ appeal.
My understood.
The appellant has put to challenge an order dated 13/3/2024 passed by a learned single judge of this court in WPC number 10942 of 2023. Stop. He said WPC number 10942 of 2023 was filed by the respondent, putting to challenge an order dated 17/3/2023 passed by the learned single judge, passed by the learned district judge Sundargarh in election petition number 2 of 2022. Stop. Next. In our view, the present writ appeal against the impugned order, which was apparently impugned order of the learned single judge which was apparently passed in exercise of power under Article 227 of the Constitution of India cannot be entertained and deserves to be dismissed on that count alone. So this appeal is accordingly dismissed.
Item number 4.
May it please your lordship.
Yes.
Say intra-court appeal, the Honorable Single Judge by Annexure 1 to the writ appeal has been pleased to allow the application which was filed at the instance of the widow of the original lessee. What has happened in this case is Raulkela Development Authority had at one point of time granted the lease in respect of the particular premises at Raulkela in favor of the husband of the writ petitioner. Then the writ petitioner thought of alienating that property in favor of a third person. And accordingly, as per the terms of lease, he had to apply before the Raulkela Development Authority, for which he did apply. And the Raulkela Development Authority insisted upon the no objection from the or deed of relinquishment from the other legal heirs of the original lessee. That means her husband. That was impugned before the Honorable Single Judge, and the Honorable Single Judge has been pleased to allow the writ petition, saying from running page 24. Internal page 9, paragraph 15.
Yes.
Application for third party transfer of the case house was rejected by the RDA only on the ground that after death of original allottee, all the legal heirs have equal right, title and interest over the suit property. Apart from that, one of the legal heirs, namely Paresh Kumar Das, the opposite part number 5, who is now the appellant, was filing repeated objections stating that his mother has no right, title and interest to transfer the case house. Such an observation has no legal basis at all in view of the fact that lease cum sell deed under Annexure 2 in respect of the case house has been executed in favor of the petitioner only. Thus, the opposite party number 5 cannot have any objection with regard to right, title and interest of the property in respect of the case house. No relinquishment deed, an NOC from the legal heirs of Basant Kumar Das, the original allottee, is necessary for according permission to the petitioner for third party transfer of the case house, as none of the legal heirs except petitioner has any right, title and interest over the case land after the lease cum sell deed under Annexure 2 was executed. Now, the Honorable Single Judge had proceeded on the premise that after the death of original lessee, since no objection was obtained from all the legal heirs to get the lease in favor of the deceased.
Who was the original lessee?
One Basant Kumar Das, father of the present appellant, husband of the writ petitioner.
Yes. Then?
Then that is how the Honorable Single Judge has been pleased to pass the concluding.
No, what he died. Original lessee died.
Yes.
When did he die?
He died sometime in.
All right, that is not very relevant.
Yes.
Then who are you? Who is the opposite party respondent?
The present respondent number 1, Annapurna Das, was the widow. She wanted to, for whatever reason maybe, she wanted to alienate in favor of a third person. After the lease was executed after the death of her husband in her favor. The original lessee died. After his death, the lease was again, after the no objection was received from other legal heirs to get the lease in her favor. That was executed, that lease.
So whether lease was executed later in favor of Annapurna Das?
Yes. Thereafter, she wanted to alienate in favor of a third person. Now, the present appellant before your lordship objected before the.
Who is for the other side?
I'm there for the other side.
Yes.
Your lordship will kindly see. I'm filing my
Please
appearance.
come this side.
I am for the development of it. 4 and 5.
Please come here.
Now here, initially the property was leased out in favor of the husband of the present respondent number one. Now, on death of the husband, the question arose what is to be done, and there are family arrangement where three flats and buildings have been allotted in favor of the present applicant. Those are not very much relevant, but I beg to point out that to your lordship. And so far as these property is concerned, which was in the name of the husband of the respondent number one, all the heirs gave no objection. One thing the land council, Mr. Das, is missing is that a fresh lease deed was executed in favor of the present respondent number one. If your lordship sees the writ petition, the lease deed has been annexed, because here only the impugned order has been annexed and no other document has been annexed. In the lease deed, your lordship will see page 18 of the writ petition. It is specifically stated that the consideration amount and everything has been paid by the present respondent number one. And this is a fresh lease deed. It is not a case of the respondent number one succeeding to the other one on the basis of no objection.
But how fresh lease deed could be executed in your favor?
That is what the Honorable Single Judge has dealt with. The fresh lease deed that was executed has not been challenged by anyone. That was executed on this fresh lease deed, my lord, was executed on 14th October 2015.
For said Basant Kumar Das died, leaving behind a petitioner widow, 3 sons and 1 daughter. Then the opposite party number 5, Paresh Kumar Das is one of the sons, so and so. After death, after death of said Basant Kumar Das, all the said children submitted notes in the shape of an affidavit before a Rourkela Development Authority to mutate the case house in the name of petitioner. Accordingly, fresh allotment orders. That is the
Matter. And it's not exactly case of mutation, it's a case of fresh lease deed.
No, it's a case of mutation. Mutate the case.
Matter.
The no objection was to mutate the case house.
So if your lordship sees
After his
paragraph,
death,
except this son,
be
in the name of petition. That is was made in favor of one.
one in
The
2015.
Rourkela Development Authority can only
Now,
say.
what is challenged is not the lease deed. What is challenged is an objection was raised and my plea for transfer has been rejected. That was allowed by the Honorable Single Judge. So till date also the lease is not under question. That your lordship will find from paragraph 12, 13, 14, the observation of the Honorable Single Judge, that is at page,
no, the difficulty is that you are creating a third party right.
yes, madam. Because the lease deed is
If
in
you
my
are
favor.
creating a third party right, then you must have a clear title.
That is evident from the lease deed itself, your lordship.
So
Lease deed, your lordship.
lease deed.
But lease deed, my lord, it creates this is for 90 years. This is for 90 years, your lordship. And your lordship sees the also mischief part of it. The son has come up in appeal against the mother. No other heir except this appellant is objecting to this. 2015, the lease deed has been executed in my favor in absolute terms. And the lease deed says, whereas the lessee has made payment of the cost of the house along with the cost of the land and has been in possession, my land, may kindly bear with me. I'm assisting the Honorable Court. Whereas the lessee made payment of the cost of the house along with the cost of the land and has been in possession and enjoyment of the said house. This is the present lease deed, your lordship. So therefore, it is on the basis of payment and everything made by the respondent number one this absolute right has been given. So what I humbly beg to submit, the entire intention is she is 90 years old. Now, if this gets dragged on and she has been thrown out of the house, she filed that before the authorities that after all the settlements were given and 3 plots and flats were allotted to the appellant, now she was thrown out of the house, not taken care of. So she needs fund. So she wanted to transfer. So in this context, my humble submission is here absolutely, and this is not under challenge anywhere till date, 2015, 2024, almost 10 years. This is not challenged. I challenge the denial of permission, and the Honorable Single Judge has dealt with that from your Lordship. The learned counsel, Mr. Das, placed from paragraph 15, if your Lordship peruses from paragraph 12 onwards, 12, 13, 14. There it has been dealt with in detail, which I think Honorable Justice, my Lord Justice Raman has been pleased to take note of that part of it, my Lord.
Yes.
And I will humbly submit this is only to drag on so that because she is now 90, she may die. That is the intention, to deprive her.
Maybe whatever intentions, we know what the sons are these days. But the law has its own course.
Law, my Lord, my humble submission would be, if your Lordship look at 117, on the basis of which this legislation has been executed, 117 of the ODA Act. This is a absolutely fresh authority. That is what, had it been a case of, I beg to humbly clarify. Suppose, hypothetically, all the heirs, namely the mother, respect number 1, and the other children, the appellant and other children.
Let us see where is the lease deed.
Yes. Only before that, may I just point out one thing.
The lease deed was executed when?
Lease deed was executed on 14th October 2015. And here only one thing I will to point out, had it been a case of succession, it would have been recorded in the name of all. But that is what is to be done. So it's a case of others give no objection in favor of one.
It has not been recorded in the name of all because they wanted that name of only one should be there. That is only for the purpose of mutation, that does not confer any title.
That your Lordship may see the no objections also. If at all no objections, they have not filed the no objections for your Lordship, your Lordship will see the tenor of the no objection also. But the no objection I have stated in my writ petition was because of the fact they had many properties.
What is the consequence of no objection?
I'll say one thing here. Even assuming, no, by virtue of this phrase, it has been in my favor since 2015. Assuming that they say that no, they have a right over it. So they could have even challenged this deed itself, which has been there. So now I want to transfer. My challenge is, their challenge is only to the transfer, nothing beyond that.
They are not.
So they say it should be with you.
See, the development authority has declined. You wanted to transfer.
No.
The development authority has declined.
No.
That order was under challenge.
Yes.
That order has been interfered with.
No.
So the development authority was right.
Development authority, in my humble submission, Mr. Malad, in view of this absolute nature of the deed, your Lordship may peruse the deed. Your Lordship wanted to see the deed. That is at page 15 of the writ petition, Malad, which is on board before your Lordship. It is there on board.
1607.
400.
Writ petition has come on board, Malad. It's
Yeah.
there with WPC 1607.
Sorry, opening. Or submission is to be accepted, then that NOC amounts to transfer of an immovable property in favor of the mother.
Malad, I'll just submit one thing. What the legislature speaks of is a case of giving a lease in favor of the respondent number 1. My lord, NOC was just a, because the other heirs are there. So therefore the NOC was there. So far the transfer is concerned, as your lordship was pleased to point out, it will require stamp duty. I'm conscious of that. But if your lordship will kindly look at why the stamp duty was not levied, 117 of the Orissa Development Authority Act exempts the authority. My learned friend, my beer, I'm
Let us
asking on
see,
the
let
point
us
of
see,
law.
let us-
My lord is
Don't
asking
be
me a
impatient.
question. I'm assisting on the point of law. But your lordship will see that has been mentioned in page 16 of the list deed, that in view of 117, we are exempting you from that. So otherwise, as your lordship was pleased to point out, since it is a transfer, my lord, transfer has to visit with the stamp duty and whatever is under the Indian Registration, Odisha Registration Act, my lord. I have nothing to dispute about that, my lord. This special statute has made a deviation from that and provides for an exemption in terms of 117, for which reason that has not been levied.
See, that will amount to relinquishing their rights.
Yes, that's what I
So
make from it.
that will have to be done in accordance with law.
Now that has
You
been
see,
done in
NOC is not that. Let us see section.
my lord, your lordship may kindly see. Page, section 115, 117 and 118 of the Orissa Development Authority Act. And this is a registered document also.
So that is not the question. The question
Right.
is of title. The question is of right to transfer.
Section 115, 116 and 117. 116 is not there, 117, your lordship may kindly see.
Yes.
Section 115 says, nothing in the Indian Registration Act shall be deemed to require registration of document, plan, map prepared, made or sanctioned in connection with development of plan or town planning scheme which has come into force. All such documents, plans, maps shall for the purpose of so and so be deemed to have been registered in accordance with the provisions of the Act, provided that documents, plans, maps relating to approved development plan scheme shall be accessible to public in the manner prescribed by regulation. Then 117, notwithstanding anything contained in Indian Stamp Act, and no duty shall be imposed on any deed of transfer of immovable property either by or in favor of authority.
So that is in favor of authority.
By or in favor.
See, there is difference. There is difference. It is between the members of the family.
No, this is by the authority in favor of appellant. By or in favor of.
Favor of apparent, this is a different thing.
Mal.
The question is that you will have to imagine what happened soon after the death of Basant Kumar Das. And
Right.
then you will have to proceed.
Mal. And that is how they have not
That
done
is
this
how-
case only. They have done it in
It is how,
every case.
in what circumstance you can say that their right over the property extinguished? How can you say?
But, may I just point out one thing? I will not say that it's a doctrine of res judicata or anything that will have a prevalence, but fact remains, if your lordship will call for the record, your lordship will see in each and every case where some of the heirs don't want and
We
they
don't
want to
know.
relinquish,
We
it is
will
on the
see,
basis of NOC.
Mr. We will not be guided by what has been happening in the development authority. The
Right.
law will guide us.
Much obliged. That is why I
Yes.
put a rider while
So that
making
is the
this.
law.
I put a rider while making this submission that though, my lord, I cannot say, my lord, that that will be the law, but fact remains each and every case where the heirs, some of the heirs want to relinquish, it has been on the basis of NOC and fresh lease deed has been executed.
Presley has the law will decide.
And
The law will-
one more thing I
Very
want to point
difficult.
out, the lease deed having not been challenged anywhere, it stands as it is, but there cannot be any objection from the appellant. That is what I will point out, because lease deed, validation of the lease deed is not in question anywhere. Your lordship will kindly consider this aspect of the matter. So far as the lease deed is concerned, it has not been challenged by the appellant, saying that no, my NOC was not for this. And my lord, once this lease deed is there, what
Do you have your title over the property
by virtue of the lease deed, that is what I.
by virtue of lease deed?
Yes,
So they are objecting to it.
my
Objecting it, their objections were sustained.
objection has been sustained.
You could have filed a suit
My-
seeking your declaration.
My your lordship
You are-
kindly consider, this is a case of transfer. And suit, your lordship knows, my lord, if I file a suit, possibly, my lord, I'll not be there even to.
Therefore, writ. Therefore, writ.
No,
Writ
it
is
is not there for read. what I beg to submit, challenges to the action of a statutory authority and a writ is maintainable. It's not that a writ is not maintainable.
The statutory authority says you don't have right, this court says you have right.
Your lordship will kindly
So
consider.
this court in writ jurisdiction has decided your title.
May I humbly submit one thing? Statutory authority having executed the lease deed in my favor would not have dashed my submission, said that. That's what I beg to point out. My statutory authority having executed the lease deed in my favor would not have said that no, your application is rejected because one of the son is objecting. That is what I beg to submit. It is not a case of my lord.
Yes, sir. Any? Anything? What is your? Future depends largely on the nature of sons do you have. We don't know if one is alive, then you will have to suffer. It's not a question of the law has its own role. Why don't you resolve it?
That
Why
can,
What
can't you
more he
resolve
wants?
it? Just
that can be, if your lordships intervene, that can be.
resolve it.
Yes.
Sit all the your senior counsel, his senior counsel. Please convince them. These are small matters. Please, all of you sit.
I was just
And
wondering whether a son and mother should fight.
They may. Because you cannot stop. And the court will not decide on the basis of their relationship, but on the
Absolutely
basis
not.
of law.
But the other day, I was in the court of Honorable Justice A.K. Mahapatra. One client appeared personally and started crying. Honorable Judge said, I will not decide the case on the basis of you being emotional. I will decide on the basis of law. So
Exactly.
it's not a question of that, my lord. It has to be on the basis of law.
Exactly.
As revealed
Yeah.
from a.
So your lordship may,
Just a minute.
therefore it will sit together. Kind of.
Uh,
My
After having
appearance,
heard
my lord,
and
is allowed
counsel
to
appearing on behalf of the parties and considering the nature of dispute in the family, the court considers it appropriate to adjourn the matter for 2 weeks so as to enable a senior counsel representing the parties to explore possibility of an amicable settlement of the dispute. Stop. List this matter on 2 weeks within first 5 cases. Do it.
My-
Please
May I beg
convince.
your lordship, pardon my lord, it's all right. I know, nowhere they are in their mutual adjustment. But one point, there's a mistaken of fact, my lord. One point I want to beg to clarify, my lord.
Next day.
If I counter affidavit,
Next date, my lord says next date.
Next day you clarify. But in the meanwhile, all of you try.
My lord, I'll definitely.
You try, you may say your
you-
client and Mr. Senior Counsel, you know the legal position better than anyone. So you can also tell.
My lord, interestingly, I beg
Tell
to
them.
point out one thing. I joined as a pupil when my learned senior was there in the office of senior counsel, Mr. Surya Prasad Mishra. So we helped from the same Sirasta.
Yes.
So I joined in 91. My learned senior was already a senior lawyer by then. I was following him only.
All right. So please try.
My,
Because these disputes are very disturbing.
my,
But when they come to the court,
but it
They have to
hurts
be
me. I always
adjudicated
wonder,
upon it,
can the
court.
parents be treated this way? But it has to
they
be
can
resolved.
be.
My-
It depends on the kind of son
My-
or the grandson or you have.
Mother's anxiety is only about her maintenance towards the last part of life. If that is taken care of, everything is over.
No, let there be a resolvement. Because there are
Why
something
not?
beyond the law
Please try.
in between. I hope
Try.
we can resolve
Why
it.
I
doesn't
think
boil-
this son has already got some other property
Three
in his
flats.
name.
Flats and property. But now taking advantage of the legal position, all these challenges.
So you agree that he is taking advantage of legal position.
My lord, as a senior counsel, it's my duty
Yes.
to assist your lordship.
Right,
my lord.
right,
Right.
Apart from that, I may justify, but I have to assist.
May I
properly.
pray for an interim order? Because
In the
But
meanwhile,
since we are all appearing, do your lordship feels the authority will do anything?
in the meanwhile, the parties shall maintain a status quo.
progress.
Item number 5.
Well, item 5, under Annexure 6, which is the Orissa Elementary Cadre Amendment Rule 2019, under which, under para 15, the rule 15(2)D, exemption to a particular
Based on my personal experience, I must say that the number of cases challenging virus or statutory provisions in Odisha High Court is more than any other high court in the country.
Well, because your lordship will come across, yes, my lord, without looking to the Central Act and some
Let us see-
principal
let us
provisions,
see. That,
it has
that
been
will not
inserted.
prejudice us. Let us see where is that.
My lord,
Which provision you are challenging?
my lord, your lordship, that is 15(2)D, page, your lordship, Annexure 6, page 59. My lord, I may be permitted to say also, my lord, 3 cases on the same point is pending and it was in board for 4 weeks. Last 2 occasions, they have taken time in which that batch, they have already filed counter. And
So
rejoinder
this
has
can
been
come
filed.
along with that. Can this?
Yes, my lord, let it come, but for this present week, it has been delisted, my lord.
Huh?
For the present week, it has been delisted. For last 5 weeks, it was in the board. And in 2 occasions, it has reached where the
Challenging
government
same-
council has taken time, despite
challenging-
counter rejoinder.
Challenging the same provision.
Yes, my lord, the same provision.
Is it so?
Yes, my lord. No, lord, that is number is, your lordship, my lord was pleased to pass this order.
Odisha Elementary Education.
Yes, yes,
Method
my lord.
of-
Amendment Rule 2019.
That is under challenge.
My lord.
So we can list this matter. You know, I have counter affidavit is needed.
My lord, counter and rejoinder has been filed in one of the cases that has been adopted in all the cases. Even additional affidavit which I last occasion
Stated
played, that has
by
been also filed.
and counsel appearing on behalf of the parties that on behalf of the petitioner that the legality of proviso to Rule
15(2)D, where the
15 to B, which is under challenge in the present writ application, is also under challenge in case of WPC number 17780 of 2023. This is the
my lord.
and other connected matters.
Yes, my lord. All the other connected matter.
Of this matter with so and so on.
My lord, may I pray, my lord, at this juncture, my lord, with permission. My lord, what has happened in the meantime? My lord, the state opposite parties are taking steps to give promotions to the not qualified, the candidates not having the requisite qualification. Whereas we petitioners are there. Now it will lead to the complication. Since it was last for five weeks, it was in board and they have taken time, matter can be sorted out in view of only 3 provisions. Section 23.
So unless we take up the matter, how can you argue?
Only I pray, my lord, I am not going to, my lord, elaborate. Only I pray, my lord, let it come, my lord, on the at 2 p.m. your lordship will fix, my lord.
Or let the matters come first. Thereafter, we will fix if required.
Along with that batch, my lord.
Yes, yes. Let this matter come and then we will fix.
Because that was in batch matter was in board, my lord.
Item number 6.
Yeah, please, your lordship. This is a public interest litigation, but the advertisement is in vernacular. I beg to my lord, I may give the translation, your lordship may take it
The
up next
counsel
week.
appearing on behalf of the petitioner seeks adjournment to provide
Translated for
translation of annexure.
Annexure 1 and
Annexure 1.
yes,
Annexure 1 of the writ petition. list this case on 2 weeks
Next
for the
week,
said purpose.
next
Item
week,
number 7.
can I pray next week, my lord? I'll
Let
give it
come
by.
up for 2 weeks. In the meanwhile, let some other matters also be taken
Mal.
up.
Item 7.
May I please, your lords? Let, I pray for 10 days time to file my objection.
Objection,
Objection. So cause,
contempt petition.
so cause, they filed the so cause. So I want to
Reply
resign.
to so.
Reply to so called. Let us
Yes.
see what was the order. So there is no order. No contempt. So whether any action has been taken,
My lord,
what is your reply?
reply your lordship may see that reply are is in twofold. First is, he is not a street vendors. He has annexed the trade license to the writ petition and he is claiming that I am a street vendor. Under the Street Vendors Act, there is a provision that if you are a street vendor, then necessary certificate will be issued in your favor. That is, he is not at all a certificate holder under this act. And by misleading that I am only, he is having a trade license only. So trade license certificate and street vendor certificate are two different under two different laws. Number one. Number two, so far as he was unauthorizedly occupying GA department land for which BDA has, there is a enforcement team of Bhubaneswar Development Authority, and that Bhubaneswar Development Authority, the letter number I have given, they have evicted him from the government land for following due procedure of law, not the BMC.
But the BDA was not a party to that writ petition also.
We understand. The present contempt application has been filed alleging violation of this court's order dated 3/4/2023. Stop. The 23 passed in WPC number 3376 of 2023. Stop. The petitioner had filed the said writ application seeking direction to the Bhubaneswar Municipal Corporation.
Yes, ma'am.
Bhubaneswar Municipal Corporation not to close the vending unit of the petitioner at District Center, Chandrasekharpur, Bhubaneswar without due procedure of law. As in street vendors, as provided in street vendors bracketed protection of livelihood and regulation of street vending bracket closed act 2014. Stop. The a coordinate bench of this court disposed of the said writ application with the following direction, paragraph 4. Stop. So-called reply has been filed on behalf of the
BMC.
BMC. Why don't you ask BMC to have one standing?
That is
counsel?
already done, your lordship. There are
It has been
standing
done.
on so far, your lordship. has
Panel of
directed
lawyers
the
is there,
BMC.
BMC.
That has been done and a letter has been given to the register. But subsequent circulation by register.
Accordingly,
No, I think
this
BMC
Cuttack
management-
Municipal
As
Corporation,
per your lordship direction, they have appointed Mr. Ponda to receive all writ petitions so
Okay.
far as
Single bench are concerned.
And
And
so far as
division of bench
division
concerned,
bench,
Mr. Bhanti.
I am entitled to receive the call. That may be circulated, the registry has received the note, letter from. the-
that shall be circulated.
Yes.
Oh, circulated.
You are appearing.
Yes, my lord. In last two items, I am appearing, my lord, contempt number 26 of 2020.
Same matter.
Yes, same matter.
Is also
Same
with
time.
us. Is also with us.
My
Both 7 and 8.
focus.
That the petitioner does not have the, what is that called, certificate?
Yes, ma'am.
Certificate of vending certificate.
Vending
Under the
certificate,
Street Vendors Protection of Livelihood and Regulations, Street Vending Act 2000, under the Street Vendors Act
under the
2000,
act. Under the act.
2014.
And therefore, the said provision has no application in his case. First off, he had relied upon a trade license issued in his favor, which cannot be treated as a certificate certificate under the act. First off, it has secondly been submitted that an action for eviction, an action for petitioner's eviction has been taken by the
Bhubaneswar
Bhubaneswar
Development
Development
Authority
Bhubaneswar Development Authority
by following due procedure.
by following due process of law. First off, it has also been, it has been submitted on behalf of the opposite parties that Bhubaneswar Development Authority was not included as a party in the writ proceeding. First off, next, after having considered after having perused the order passed by this court, violation of which has been alleged in the present contempt application, so cause filed on behalf of the contemners, and having considered submissions advanced on behalf of the parties, we are of the view that no case of deliberate disobedience of this court's order dated 3/4/2023 is made out. So the contempt proceeding is accordingly dropped. Yes.
Item 8 is same.
My lord, I want to file my objection, my lord, to their so cause.
No objection. Not required.
My humble submission is, my lord, in two
The-
content
it
matters,
goes
now
without-
Mr.
it
Vijay
goes-
Kumar
it
Das
goes
kindly.
without saying that if the if the petitioner feels aggrieved by the action of the opposite parties in evicting him, he shall have liberty to approach, to take such legal recourse
That
as
in-
may be.
In place of opposite party, it may mention Bhubaneswar Development Authority.
Bhubaneswar Development Authority. It shall be at liberty to take recourse to appropriate provision of law, if permissible. As permissible. Yes.
Item 8.
Same.
Which said.
7 and 8 both are same.
7 and 8, all right.
Item number 9.
My lord, it has already been complied with.
Compliant. You have given us the list.
Yes, I've given, yesterday I've given.
So we are in the process of notifying them and then.
Rest I'm trying to get it now.
Okay.
Ten.
Non-compliance order dated.
Order has been complied. There is a direction to minutes, consider the repentance and dispose of minutes. It has been done. I'm giving a copy to my friend minutes. Also copy to the lordships. It has already been done by the minutes collector. By the order dated 19/4 minutes.
Yes. It has been passed. It is not in dispute that this court's order dated 11/1/2023 has been complied with, though belatedly. full stop, though belatedly, in as much as a reasoned order has been passed. Full stop. Considering the fact that now this order has been this order dated 11/1/2023 has been complied with. We are not inclined to proceed any further in the present contempt matter. Full stop. This application. The proceeding stands stopped.
Item number 11.
May I please the lordship? On behalf of Mr. Mahanti, I may be permitted to submit. Here it is a case, my lord. The land acquisition was taken up and the government in exercising their power of eminent domain.
No, it's contempt petition.
Yes, contempt petition. I have not been paid a single pie towards
Just
my.
let us see the order.
Yes, order is available to your lordship at annexer. I'm holding my second one. Both and the lordship can see the order at page 10.
Yes.
Direction was to dispose of my representation considering the government notification at annexer 14. The lordship can see page 9 rather. In course of hearing and
So whether
counsel-
this order has been complied with?
Yes, please.
No, my lord. According to me, my lord, they have not complied with it. That too after.
Just a minute.
Sir,
What was the direction?
direction was to dispose of my representation with regard to payment of my
So
compensation.
whether the representation has been disposed of or not?
No, without taking into consideration annexer 14. That was the specific direction. Annexer 14 says, my lord, if there is no award. In fact, there is no award in my.
Just a minute, let us see the order.
Page 9.
Yes, annexure 14 has not been taken
Yes,
into
Lord.
account.
It has been directed that the matter has been referred to the civil court under section 30 of the act, and the amount has already been deposited in that court. So it has been requested to approach the court and get the amount.
It is not in my favor, sir. It is not in my favor.
Then you can
It is in
challenge.
favor of some person,
Yes,
and I was never given an opportunity. A two-story building was demolished
you can.
by force.
You can
Despite
challenge.
of status quo order passed by this court. There are series of litigations in this
You
case.
can challenge that order.
Yes, my lord, I'll challenge. Let him serve a copy. Your lordship, that's a copy of compliance he is not served.
I will give it just now. No problem.
Your lordship kindly allow me 1 day time, my lord. To an 80-year-old man
It is-
running
it is-
from pillar to post to get his legitimate
It is stated
expertise.
by learned AGA that this court's order dated 1/3/2023 has been complied with and an order complied with and the petitioner's representation has been disposed of as directed by this court,
After delay of 1 year.
though belatedly. First off, a copy of the order showing compliance, a document showing compliance of the said order has been is being served upon learned counsel for the petitioner. First off, place this matter tomorrow.
Day after. 80-year-old man, he has to come from Bhubaneswar. 80-year-old man.
Monday.
Monday.
Item 13.
11, 12, same.
12.
12 is different.
Item 12.
12, I filed a compliance affidavit on 23rd of April.
Same, similar matter, my lord. Your father and daughter. Same matter.
Same.
Item 13.
My lord, in this case, petitioner prays to initiate the contempt procedure. Last time, the government counsel was directed to take instruction. Last time, direction was made to take instruction.
You must have received instruction.
Because I received instruction, I've been requested by the authorities, also can look at. The order has been completed because there was a direction, he has been given promotion, but there was a direction in his case for promotion to the post of stenographer. For regulation post against the post of stenographer should be considered. Now they've given a reply saying that at that point of time, the post of stenographer were not there, so his case could not be considered. If you also want.
So what is the order? Let us see.
Earlier, my lord, by the annexure 1, my lord, the tribunal has passed the order. Annexure 1, page 6. The relevant is page 10, my lord. Paragraph 5, page 10, paragraph 5. Against this order, the state had come, my lord. And the writ petition was dismissed, my lord.
No, to-
By the
you are-
annexation.
you come to paragraph 6. In the order. at
Yes,
page
my
11.
order, the paragraph 5 is the relevant one. Page 10, my lord. The prayer, the other prayer for issuance of direction to regularize services from the date of his first appointment on 21/1/1980
So what is the direction?
to regularize his services in the post of stenographer instead
That
of.
order is there in paragraph 6.
Yes, ma'am. Taking all the above steps into consideration, and since the applicant has been regularized as a Khalasi, we direct a respondent to consider for his regulation against any vacant post of junior stenographer that might be available with respondent number 2. And he will get seniority in that rank from the date he has been regularized in the post of the Khalasi.
So that was only for consideration,
My lord.
nothing more.
No, against that, they had come, approached the.
They approached this court, but this order remained, paragraph 6. Paragraph 6 had directed the respondents to consider his regularization. There is no direction, there was no direction to regularize. So that has been considered, they might have allowed, they might have rejected. What have you done?
They have not given any petition.
No, so I've got the instruction, if my friend wants, I can file an affidavit saying that no, there was no vacancy on that particular date.
No, whether that has been considered or not.
Yes, but it's considered and they've instructed that because of
So if your case has been considered, you can challenge that. We will give you that liberty.
I have no knowledge, my lord, that is the only.
one thing will also call next week, I will file that affidavit so that it can be.
On behalf of the contemners, list this matter on 1 week.
Item 14.
May I please, Your Lordship? The order dated 27/9/2023, para 8 has been violated. And your lordship's last occasion on 4/4/2024 directed to take instruction as to why the orders are not been complied with.
No, so I have already filed a
They have filed a
compliance
reply
affidavit.
saying that the matter is referred to the law department, thereafter GA department, PG department for views. Views. My lord, this honorable court clearly directed for my appointment. They are considering the views of the sending the file to the different
Where is
department.
the direction?
No, in fact, what my
Direction
friend.
para, page
Friend-
14 para 8.
No, if they have violated the order.
No, no, I'm not saying that I've complied with, I've said that 2 months' time will be granted to comply with lordship's order. I prayed for time only,
This
no.
order was passed in
Right, bro.
2023.
Yes, no, 23. And now, not after this paragraph 9, I've said that
So
because.
we will take up soon after the.
Yes, bro. After the holidays, so in the meantime, I will comply the order.
And 4/4/2004, your lordship directed to take instruction to comply the order.
All right. You have two options. See, the scope of contempt is very limited,
Well,
either to punish or to,
implement.
no, implement, they may decide to be punished instead of implementing the order. And that will not give you any benefit,
Well,
as requested on behalf of the contemners by way of last indulgence. The matter is adjourned to 20 June 2024. Stop. The court will take serious view of the matter if in the meanwhile this court's order dated 27/9/2023 passed in WA number 1739 of 2022 is not fully complied with. Yes, happy?
well.
Matter.
The 15, your lordship's order has been complied with. His representation has already been considered and disposed of. I've given a copy to my friend also.
Complied with.
Item number 16.
Arising out of OGLS matter, my lord, vis-a-vis Odisha Servant Settlement Act. Lease was granted to my vendor, my lord, and I purchased this. Several persons
So whether
purchased.
the, what was the order?
Order was to comply, my lord, the Honorable Single Judge order was complied with in respect of my neighbor. And patta was issued. What happened during settlement operation? It was recorded indiscriminately in the name of government. Several persons came
There
and
was no
challenged.
direction.
Pardon?
There was no direction.
Yes, direction to comply in view of the 27379. 27379 WPC is at page 12.
No, please come 2/8/2022.
Yes. The direction was,
Huh.
Lord Single Judge, the order of Honorable Single Judge, which was passed in respect of similarly situated persons, that to a neighbor, it was
You are,
approved.
just a minute, you are alleging violation of which order?
This order at page 10.
Page 10.
I approached the Tahsildar. Tahsildar, what he did, he remained silent.
Sir, please let us come to the direction
Yes,
first.
yes, ma'am.
What is the direction?
Direction was petitioner is at liberty now to approach the Tahsildar in view of the order passed in WPC number
So
27. I
There is no
had
direction.
approached, my lord.
But the
He
matter is
remained
over.
silent.
The matter is over. There is no direction.
He remained silent, my lord.
He has the right to remain silent because there was no direction.
Direction because of, my lord, he has approached in two different similarly situated persons.
Petitioner has alleged disobedience of this court's order dated 2/8/2022 passed in WPC number 29171 of 2023.
I pray to withdraw this with the liberty to file a
For the
press.
petitioner, and counsel for the petitioner after some argument seeks permission to withdraw this contempt application. This application is accordingly dismissed as withdrawn.
With liberty to file a press. With the liberty to press writ petition because of my cause of action survives.
Liberty is always there.
My cause of action
Liberty-
survives, otherwise I'll be misunderstood now.
Item 17. Item number 17.
Here it's non-compliance of order with regard to Milord's appointment on the rehabilitation assistant Bindu Sagar. Now the matter is pending. If you will also kindly come to
Item 17.
17, no?
Hmm.
It's connected to Bindu Sagar case, Lord, the rehabilitation assistant.
Bindu Sagar case is pending
Pending
before.
before, so gossip, in IVG.
We have very limited role. Is the contempt is measured or not measured? That is the question.
Mayor, please, Mayor, it is a press matter, Mayor. And in the first time, the complaint and I mentioned.
Where is the order?
Mayor, the order is Mayor, National 1 Mayor. Page
25/9/2023.
Mayor, page 23 may kindly see, Mayor.
Yes.
This is the direction of the Honorable Court, Mayor. Would add the appellant to consider the case of the petitioner respondents within the period of 4 months from today. For that, the state shall form a
But this
special.
order is under challenge.
Order is under challenge, Mayor. But till that no order has been passed before the apex court.
But
Honorable.
the matter is pending. We should not proceed. And when if the once that is decided, you may come before this court.
And till that, no stay order or any interim order has not been passed by the apex, honorable apex court. Mayor. Several times that has been taken up by the honorable apex court, but no interim order till date has been passed. In the meantime, Muller. 25/9/2023 order is passed, my lord.
Still, the order was passed on 25/9/2023.
Hmm.
We are in May 2024.
Hmm.
They have already preferred SLP.
Hmm.
So they do not have any intention to implement the order. All right.
Hmm.
They see if an order is passed, party has liberty either to accept it or reject it. So they have rejected the order. They have filed SLP.
Hmm.
So as on date, no contempt is made out. We will give you liberty to file your contempt petition later, say after 1 year or whatever.
Well, the date is fixed, we were honorable appeals court, 6th, my lord. It may come thereafter, my
No,
lord.
no, we will not wait. Otherwise, it will be unending process.
My lord, it may be urgent to after vacation, my lord.
We will give you liberty. We don't know. We will give you liberty to file a fresh contempt application.
Yeah.
Because then, as on date, we are not satisfied. So after 1 month, after 2 months, after 4 months, you may come again. You can say that liberty we will give you, and you may not have to come. If finally the Supreme Court decides the matter in your favor, then they may implement the order. So you may not have to come after that. As on date, no contempt is made out. Because the disobedience must be deliberate. The petitioner in the present contempt application has alleged disobedience of an order dated 25/9/2023, passed in whereby WA number 1354 of 2022 came to be disposed of in view of a common order passed on the same day in WA number 810 of 2021 and batch. Full stop. Next, it is not in dispute that the state of Odisha has questioned the state that an SLP has been preferred by the state of Odisha against the said division bench judgment dated 25/9/2023, passed in which case? In Bindu Sagar. Bindu Sagar.
Yes. That is there.
Not mentioned.
Double number 810.
Anwar. Okay. The state of Odisha versus Bindu Sagar Samantre. What's up? Next, learned counsel appearing on behalf of the petitioner has submitted that no interim order has been passed by the Supreme Court on the appeal preferred by the state of Odisha, and therefore disobedience of this court's order dated 25/9/2023 is deliberate. Next, be that as it may, as since the contemners have approached the Supreme Court against an order, violation of which has been alleged in the present contempt application, we are of the view that no case of deliberate disobedience of the said order of the court is made out. Stop the contempt. This application is accordingly disposed of with a liberty to the petitioner to approach this court again, comma, later, again at appropriate time.
After disposal of the.
No, that you are not saying. Therefore, if you say if the matter remains pending for long in Supreme Court and your this order is not implemented, then you can make up. It is too soon for us to take a decision that they have committed contempt of. It's too early. Right.
Item 18.
Non-comply of order directing opposite party to consider the representation of the petitioner within 3 months.
3 weeks? As requested on behalf of the contender, this matter on 3 weeks to report full compliance of this court order.
Orders item 19.
My lord, in this case, your lordship have issued notice in the writ appeal. So notice has been issued, but service has not been made sufficient as is indicated in the endorsement in the cause list. It has not returned. Well, there are 3 cases. It has not.
So addressee left.
Sir, that is in first case. Thereafter, in second case, your lordship will say as many as 4 to 5 persons, regarding 4 to 5%, nothing is there. And there is no tracking report, no return of that notice which was sent from the registry of this honorable court. That is what has been indicated in the cause list.
Just a minute. First matter.
Respondent. Respondent.
I'm appealing to the respondents. We are in service of the reputation. However, the reputation has been served without the annexation. They're not able to file the reply to that.
No. If that is so, I will give you a copy.
Copy may be
If that is so, I will give you a copy. I do not know if he is saying, I will give you a copy. There is no issue.
Copy may be served to
Huh.
you.
Who is respondent number 6?
Ballot, I am appearing for respondent number 6. In first case and the second and third one, appeal party number 9.
First case is?
Appeal party number 6, my lord.
No. What are the cases?
Sorry, respondent number 5, my lord. Sorry, my lord. In first case, respondent number 5.
85 of 23.
85 of 2023.
First complete that. Thereafter.
So this who is R6 in first case?
Deepak Kumar Dansal.
Deepak Kumar Dansal.
Someone is appearing for respondent number 6.
Nobody is appearing.
No, 5.
5. Nobody is appearing.
So only how many respondents are there?
My lord, in the first case, there are 8 respondents, a private respondent, out of them are 4 to 8. That means 5 are private respondents in the first case. In the second case, total.
First case, let us complete first case.
Bless.
In the first case, you have appeared.
Yes, madam.
For 5.
5.
What about 6, 7, and 8?
Well, the service return has not come. There is no endorsement to that effect from the registry. Whether it has been solved or not.
4 and 6 are also.
They are appearing.
4 and 6.
I'm appealing for 4 and you're appealing for 5.
4 and 5 are appearing in the first case. Rest others have not yet appeared, nor any endorsement is there in the regarding sufficiency of service.
there is no office note as regards response number 7 and 8. Validity served. Go ahead. It is mentioned. WA 85 of 2023. Awaiting service of notice. Awaiting service of notice upon respond number R6. List this matter on 3 weeks.
After 3 weeks.
WA 86. It is noted that according to the office note, respondents number 7 and 8. Notices upon respondent number 7 and 8 have been served. The respondent number 4, you're 4.
4 in the first, in the second matter, it's 8. What is asking for?
So
Yes, 4. The
respondent
first
number
matter.
4 and 5 have entered appearance. Respondent number 1, 2, and 3.
I am.
Notices have been accepted on behalf of respondents number 1, 2, and 3. Next, WA 86. Nor undelivered notice. R5. Who you are for R5?
No, my lord.
In the
Here,
second
I
case,
am for R9, respondent number 9.
respondent number 9. Who is for respondent number 5?
Here, nobody appears. 4, 5, and 6, nobody appears.
Let press steps be taken for service of notice upon response number 5 and 10 with present and correct address. Await service of notice upon response number 11, 12, 13, 14, and 15. Yes, and next is WA 88.
Yes.
Yes. What is this? Who are these respondents?
Well, they are all working presently working as assistant drivers under the state police, police motor transport. SP police motor transport. All these persons are now working, all the respondents are now working as assistant drivers.
Where?
Under superintendent of police, police motor transport, Odisha. At different places in Odisha.
So why should we not get the Mr. You are representing the state.
Per state, their address is given. In respect of private respondents, all address has been given. So it can go in their address.
I'll take this notice after.
Your SP?
Your SP can ensure.
What has happened, my lord? Initially, they are appointed to superintendent of police motor transport, but subsequently they are posted under different superintendent of police.
Maybe.
Yes, he can. He does
So
have
it will
a place where the address is left. Means
then you'll also pass that order. I communicate it to the superintendent of police motor transport so that he will communicate the same, and he will take steps for service of the notice on them.
From the office note, it transpires that notices have not been served upon some of the private respondents in all. There are 3 appeals.
Well, there are 3
in all the 3 appeals. No problem. the said private respondents are working as assistant drivers under
Different superintendent of police, my lord.
which department?
Under police department, under superintendent of police of different districts.
Uh,
Under home department,
assistant drivers. Assistant drivers, क्या लिखे हैं? Working. Assistant drivers, police department.
yes, under home department, your lordship, say
Under
home.
home department at various places.
Yes, under different superintendent of police
Under
of different districts.
different superintendents of
Police.
in different districts. So stop. It is in the, so as to expedite disposal of the present batch of writ appeals, it is considered expedient to get notices of these appeals served upon them through the home department,
Your lordship, may say through superintendent of police, police motor transport,
through the superintendent of police,
police motor transport, Odisha.
police motor transport,
Odisha.
Odisha. Who is expected to have the information as regards their respective postings.
Yes, ma'am.
So stop. Let requisite number of writ appeals be served upon Mr. Khotiar Lanet,
Well,
additional government advocate by
By next week, I will serve,
Monday.
excepting those, for those who have already appeared.
Yes, yes. Therefore, we have said that some of them are not appeared.
my lord, may I plead the order may be.
Ah.
Well.
So this matter on after vacation.
Okay.
24th month. So, let a copy, let. You will get it. So, today itself.
My lord, fix it to 26. 24th is Monday, is 26.
26th.
Okay.
Item number 20.
Already, since Malon Senior has already appeared, I am serving a copy of the condemnation petition in course of the day.
Let copy of the condemnation petition be served upon. Condemnation application be served upon land council representing the respondent. So, what do you want?
Well, in 7 days.
Huh?
In 7 days. In 7 days, 7 days. 1 week.
As requested on behalf of the respondent. Respondents list this matter on 1 week.
Item number 21.
May I please your lordship? I'm seeking recall of order dated 16/4/24, by which your lordship rejected the petition seeking condonation of delay. Lordship may kindly see. It seems the registry had reported a delay of 298 days. It would not be 298 days. Because the review of the order that was sought was passed on 25/11/22, and even without taking into consideration the explanation submitted by the petitioner, it would come to 212 days. And besides that, may I submit, madam? I appeal for your lordship's compassion, because the man is coming from Kanpur and pursuing the matter diligently since 2019. He has, my lord, he has approached the tribunal twice. He has approached this honorable court, he has approached the honorable apex court, and now and it is a service
We have
matter.
seen the order. We have seen the order. We have not dismissed your application only on the ground of delay, but we had kept the merit of the case also in mind. And therefore, very briefly, we have mentioned the facts of
My lord, I am submitting. He was selected in the written test.
maybe the matter had gone up to the Supreme Court.
Supreme Court, yes, that is right.
And you did not seek any liberty to file a.
My lord, that is why I submitted the judgment of the Honorable Supreme Court, which said that even after an SLP is dismissed, a review would be maintainable.
Maintainable is a different thing.
So let it be given a chance, my lord. He has been serving, he has been trying for a job and diligently pursuing the matter persistently.
See, Mr. Any person should not.
That is why I prayed for compassion.
Should not live in false hope.
My lord,
Years together.
my lord, the eligibility standard was changed as a rule, violating the rule framed under Article 309 by an executive order. That can't be done, and that is how he was prevented from getting a job. That is why I submit. Let him be given a chance.
No, sorry.
Your lordship may have some compassion.
The you were not appearing earlier.
I was not appearing.
No, you should not have accepted. Should not have accepted the.
But it is not coming to 298 days.
Huh?
The delay is not coming to 298 days.
Mr. Counsel, you are seeking review of which order?
I am seeking review of the order dated 25/11/22, passed in WPC number 34.
Have you filed a separate petition?
Review petition is there. Thereafter, I filed a contract.
Filed
Review petition is there, along with a petition seeking petition for condonation of delay.
But that was dismissed.
That was this. No,
What have you done now? Why the matter?
I have sought a recall of the order.
By filing what?
IA,
IA.
my lord.
All
IA number 133 of 224.
All right. IA number.
133 of 24.
Where is that?
It has come today for orders. So it is 24.
IA number 133 of 2024. This application has been filed for a recall of an order where is that order?
Order dated 16/4/24. I have quoted in page 2 of my IA. Order dated 16/4/24. I have quoted in IA, page 2.
Yes, now I saw that. Where is the order passed by us?
Order, page 2, I have quoted the entire order. Page 2 of the IA, this 133 of 2024.
Possibly flag B.
Like B.
Pages 2 and 3, I have quoted the entire order.
For recall of an order dated 16/4/2024, passed in
RVWPET number 281 of 2023 and IA number 223 of 2023. Top by the said order dated 16/4/2023, the petitioner's review application was dismissed, after taking into account, after noticing the facts and considering inordinate delay in preferring the review application. First off, in the disposed of review application, the petitioner has filed the present application for recall of the order. First off, this application is totally misconceived and stands dismissed accordingly. Don't do it again.
Item 22.
Presence.
Item 22, there is 279 days delay, my lord. Last occasion, your lordship, I have filed an additional affidavit explaining that delay. That was filed yesterday, it has not come. Has come.
What had come?
No, that additional affidavit I have filed yesterday. Because in earlier I petition for condemnation of delay, that explanation was not proper.
Where is that decision of the division bench? Do you have?
That Surama Manjari Das, I will get
Bring that.
tomorrow.
We will see. Tomorrow.
Tomorrow or Monday, you'll ask me. Any day.
Tomorrow, let us,
I'll,
tomorrow, let it come on Monday.
yes, ma'am. I will get
So
that.
in the meanwhile, see, the law is well settled.
Ma'am.
You have to explain the delay.
Ma'am.
So in the meanwhile, just assist us
Yes, ma'am.
as to what are the circumstances and why and for what reason that decision requires clarification.
Ma'am.
All right.
Ma'am.
If that is done, we hope
Ma'am, it will solve all the problems we are facing. The government is facing many
so we will
cases.
do that.
Ma'am.
If it requires clarification, we can.
Yes, I also.
If it requires reconsideration, we can have a full larger bench.
Ma'am.
But let us think. Let us
Ma'am, obliged.
please examine.
Also that Supreme Court, when we carried that matter to Supreme Court and the Supreme Court.
That Surama Manjari Das was dismissed there on sole limit, on the ground of limitation. So I will thereafter 2-3 judgments have come, and my lord says, I will apprise my lords that under what circumstance delay can be conducted, even if that Surama Manjari Das case is there.
Yes, we will see.
Well.
All right.
Well.
We will see. If the appeal was dismissed by the Supreme Court, assigning reasons, or it was
Not assigned. No reason has been assigned.
it's just
SLP dismissed.
just dismissal of SLP.
Right.
So we will consider.
For that, SLP was also delayed.
Yes. Yes.
And I think last matter which
Mr. Dayananda Mahapatra was a Dayanand.
Susrit case is there of Supreme Court.
Yes, in Mr. Dayananda Mahapatra was doing that matter. In that case, delay of 560 days was condoned, even if that, and in some cases where on the ground of limitation and relying that judgment of Surama Manjari Das, this honorable court has dismissed the writ appeals. There also Supreme Court has condoned that delay and admitted those SLPs there. And a batch of petitions of LRC know that regarding that job contract period, pension during the job contract period. That has been stayed by the Honorable Apex Court very recently.
So please give,
Yes.
produce us all the judgments.
My lord,
so that there should be clarity,
my lord,
at least at the level of the High Court.
my lord.
All right. And at whatever level, like if we can clarify, the division bench may do. If it is required by the
Adjournment.
we will see.
Well.
But please be ready. It's very important aspect.
If possible, I'll also request my learned advocate general, he can address.
Yes, that is very important.
Yes, my lord, I'll request him.
That is very important.
Item
Monday,
23.
Your Lordship, fix it to Monday.
Monday, yes.
Yes, my lord.
Monday, or we may fix a time.
Your
Because
Lordship,
if the advocate general has to address,
my lord,
then
I'll,
we'll give you further time. We will give you 1 week.
yes, my lord. Any day, Your Lordship, in the next week, any day, either on 7th,
7th.
my lord. Item 22 and
Balakrishna case, I think you have in your favor. Balakrishnan,
yes,
Supreme Court.
23
Supreme
You
Court.
have quoted a decision, Supreme Court's decision,
in my that additional
in your
affidavit.
application,
Yes.
where the Supreme Court says that when the interest of the state is involved,
Yes,
then it is not the interest of a party.
my lord.
Right. It is not interest of the state as a party only.
My-
The state is represents the entire this thing, the public, everyone. So public represent. So therefore, in that background, the Supreme Court has made those observations which
Yes, my lord.
we will see.
Right. Then, my lord, both 22 and 23, so that your lordship may fix to any date next week. Both the matters can be addressed on the ground of delay.
428.
But say, delay.
Let there be 5,000 days of delay. In
It will be-
appropriate cases, that can be done. See, there can be a reason where an order is passed and a class 3 employee sits over the file. For some reason, no appeal is filed for 5 years. The clerk can be dismissed. But the cause cannot, in case of state, cannot be like rejected on that ground alone. So these are balancing factors. And after all, the limitation has also its purpose to serve. And other provisions, substantial law, they also have some purpose to serve. We will see. And this is our tentative view. We may mm, fully concur with the view taken in case of that Manjari.
This has been filed by the state, that copy has not been given.
Give him, give him.
Yes.
Mr. Khuntia, another Mahanadi Coalfield case is also there of our court following Susrit. You just check up. Yeah, that may be during 2015 or 16.
Well, I'll relay another judgment of 2024 also, that 1,000 days delay was also condemned. My lords expressed that taking into account the state's interest.
No, might not have, we followed the other judgments.
Surma Manjari, yes.
No. Other many other judgments.
Yes, ma'am.
So we have to balance.
Ma'am.
22 and 23.
22 and 23. Correct.
Item 24.
24, my lord, there is 40 days delay. And
Who is for the other side? Who is for the other side?
state.
And private respondent? No.
No.
Don't.
Item 25.
Delay of 32 days, these two cases, same judgment, these are 32 days delay, state is the party. Same judgment, my lord, in WA 517 and 518, and I have condoned the delay, and it was supposed to come.
32 days delay. So
Yes, it has been
Condoned.
posted to 6/5. I have verified.
Condone. Post this matter
6/5, that is.
for admission on 6/5/2024. Along with,
WA number 517, 518,
along
Of-
with WA number 517 of 2024.
517, 518.
of 2000.
24, same one judge.
Item 26.
And these dwellers in this matter, on the last day, dwellers were told me to inform the others, respondent number 1 in the other writ application. I have informed him and I have also sought a copy of the writ appeal on him. The connected matters are at serial number 76 out of the same order passed by the Honorable Single Judge. My grievance before your lordship is that in earlier writ petition, they knew that I am the owner of the property. They had included me as party. But in the present writ application, they have not included me as a party. The facts your lords will see in Annexure 2, I have given the lease deeds executed by Puri Municipality in the year 1923. That is on 13th of 2023. Since then, I am continuing and my lease continued by in the same, I have annexed all the annexures.
Just a minute.
In which
So same thing, Kumal Vijayendra Sinha.
here, my lord, I am
1960.
Datta. Municipality had leased out the land to me in the year 1923. That continued till 2003. In 2003, there was a dispute between the state government and the municipality, for which neither the state government nor the state municipality has renewed the lease in my favor. Thereafter, you will find the holding numbers I have annexed. Holding numbers, I have constructed a building. Municipality, electric bill is in my name. I have also annexed the photograph of my building that is clearly says Dr. Villa. And in Annexure 8, in the earlier writ petition, the present respondent number 1 had included me as a party. But in the present writ application against which the writ appeal arises, in that I was not made a party. My respectful submission is that since 1923, I am in possession of the land by virtue of a lease deed executed by Puri Municipality, who was the owner at that point of time.
That was extended subsequently till 2003. In 2003, there was a dispute. Even in the ROR, that is under Annexure 2 at page 24, it is clearly mentioned that the state government is a party with a remark that I am in possession of the land. In Annexure 8, your lordship will find
So let the notices be issued.
unconnected matters are at serial number 76.
This is almost the connected appeal. You just find that.
We will hear both the cases.
You almost in the park end. Was all along prosecuting.
In that
Just. He filed an application for intervention, he filed a suit which is pending, and the affidavit for the limitation, if your losses, it is, there is possible. That can establish your losses, demonstrate the Washington DC, that he was miserably failed to establish his title before the civil court. That is the reason which prompted me not to impede him as a party. There is a purely dispute between me and state government. Whether state is a, but the monies he claims title as a basis of lease, said to have been executed by.
See, do you admit that he was in occupation?
May not in respect of part of it, not in.
All right. So in part, he was in occupation, then he had a right to be impleted.
In a subsidiary, may not,
Difficult.
Your lordship, see, I can show your lordship the finding of the rent civil court with regard to his title.
No, but this writ petition, this was decided without him as a party.
Yes.
That was not permissible.
Your lordship can see the 72 case 72.
We will see both the cases. We will hear both the cases together.
But in my case, however, this court has granted me liberty to move for early disposal. It is in a bargain.
Yes.
Almost he is participating. He is also prosecuting a list there in the same
All right.
court.
List this appeal after disposal of so and so 78.
In that case, I have already intervened.
All right. So we will hear you in that case. So in the meanwhile, the order of impugn,
That
order
is there,
passed by,
in the connected office, it is there. The order of status is there.
no, in this case, whether this order has been stayed.
In that
There is
case,
a status been status quo has been passed in favor.
So
No
if that is disposed of earlier, then I may need status quo. Because once if that goes against the state government, they will immediately enter into the land.
no, let that come. Let that no entry model. If there is entry model, then
So also, man, take up this matter, you have also already directed to take up this matter at 2 o'clock, 1 week. You have also heard this matter, man, they to take up this matter tomorrow. On any day convenient to my lord.
all right, you take up.
Item 76, that is.
In the connected writ appeal, that is 226 of 22.
Yes.
Order dated 4/3/22. Till the next date of hearing, status quo shall be maintained as regards the property in question. Till further orders, the further proceedings in contempt shall remain stay.
That is in our appeal.
That is what he is saying. You are mentioning this.
Yes.
What I beg to submit to the prosecutor. Against the same judgment, and Honorable Senior has filed this. And he has also brought in certain new facts, some facts, which need to be considered by this honorable court, and on that day also.
So there are two appeals.
There are two appeals, one filed by state, another filed by.
So both the cases have not been tagged.
Now today, his appeal is today listed. in-
There are 2 years delay, sir. There are 2 years delay.
That
in
is
this
why,
appeal.
that is, just, that is why I say that his appeal should be tagged with state.
No,
appeal.
that is not required. That is, let us take up that matter first. Then we will
It is
see.
tagged up. Sir, it is tagged up. 226.
Tagged up,
Huh,
But
yes.
it is not listed along with that. That is my definition.
All right,
And
listen.
another
Oh,
thing
this
is-
has been tagged up.
On 20th, my lordship,
I could move from that.
on 20th, your lordship direct that this case will be considered along with those writ
Alright.
appeals.
To when do you want 2 PM?
Next, any day convenient to man.
Next week, correct? Eighth.
Both the
No,
cases
no.
are already
Both-
there.
Along with, then the court will also consider the question of condonation of delay in filing the application.
Item 76. Item 76 on one end. Item 76, that will be.
For admission, item 27.
In item 27, my lord, your lordship granted me time to file the counter affidavit. But I have received the instruction, your lordship grant me 1 week more time so that in the meantime I will file the counter affidavit.
You will do what?
My friend want to file counter
Counter
affidavit.
affidavit. Your lordship granted me time. I have already received the instruction, my lord. I will file it within a week, my lord.
Who are you? You are representing whom?
He is the petitioner before the trial court in a 25 proceeding against me
Here I have
after
the,
48 years of my transaction, my alienation. If my friend is so interested to file, let a date be fixed so that it will be better for me also.
well, I am the,
Let him come up with a counter affidavit. What is his pleadings?
I am repenting the DT,
No,
my
but
lord.
when did you receive the notice?
Well, it,
The transfer brief
it's
for him.
transfer, if, after fresh notice was issued, I appeared it, my lord, in
As requested on
last part
behalf
of
the
2020, December
opposite
23, my lord.
Party number 1,
You
My
are
lord,
opposite
one.
party member.
only opposite party
My lord.
on behalf of the
Yes.
opposite party,
One.
number 1. List this matter on 3 weeks so as to enable him.
May I pray before vacation any date, my lord? I have a very short point. Just any date.
Huh?
Any date. I have got the opportunity to appear before my lord.
Everybody has short point, no more.
It is my opportunity to appear before my lord. I have.
16.
As your lordship.
Obliged.
Item 28.
Please, your lordships, my lord, your lordships are in seas of that matter where section 33(2)(b), the implication of it. Lord, before going back to the section, I just want to show one judgment of the Honorable Apex Court, which was way back in 1965, after the 1959 amendment came. So the earlier only 33(1) was there. So the rest of the section was added in 1959.
No idea as well. Matter. Yes.
The lordships can just have a glance at the judgment. This was a 3-judge bench judgment. Lord, your lordships may come to internal page 5 of it.
Yes.
Just read out a small portion of it. That's paragraph 5 and there's paragraph 7. Then I'll get back to this section and then, my lord, the constitution bench judgment. My lord, it is, if your lordships got that para 7.
Yes.
It is quite clear that section 33 imposes a ban
you are
on the
reading. You are reading paragraph 5.
paragraph 7, my lord.
Paragraph 7.
Page 5 of
Yes,
that.
yes, it is quite clear.
Yes. That section 33 imposes a ban on the employer exercising his common law, statutory or contractual right to terminate the services of his employees according to the contract or provisions of law governing such service. In all cases where industrial disputes are pending between the employers and their employees, it was thought necessary that such disputes should be adjudicated upon by the tribunal in a peaceful atmosphere, undisturbed by any subsequent cause for bitterness or unpleasantness. It was, however, realized that if the adjudication of such disputes takes long, the employers cannot be prevented absolutely from taking action, which is the subject matter of section 33(1) and 2. This legislature therefore devised a formula for reconciling the need of the employer to have the liberty to take action against his employee and the necessity for keeping the atmosphere calm and peaceful pending adjudication of industrial disputes. In regard to actions covered under section 33(1), previous permission has to be obtained by the employer, while in regard to actions falling under section 33(2), he has to obtain subsequent approval subject to the conditions which have been already considered. That's why, my lord, yesterday I was telling, my lord, pre facto and post facto. So 33(1) deals with pre facto, where I have to take express permission first, then take the action. Because that is a dispute where with the original dispute, the employee is directly involved. And the reason or the purpose of giving him the protection was that just because he has raised a dispute or a dispute where he is directly involved, he should not be victimized. But in 33(2)(b), the reason is that he is not directly involved with the dispute. It may be a misconduct which is beyond that dispute.
Right.
For any other misconduct.
Right.
So that is why the post facto approval, the management has been permitted to take the action and thereafter seek the approval. That was the purpose. In that sense, it would be correct to say that pendency of an initial dispute in the nature of condition precedent for applicability of section 31(1) and 2, both. Now, my lord, I'll just take your lordships to a Supreme Court judgment, which is my lord, Constitution bench judgment.
Yes.
Lord, there is a 2002 judgment of, my lord, a constitutional bench judgment. So I'll just first read the reference that was made, and then my lord, certain paragraphs I'll just take your lordships through. Lord, if your lordships would come to page 4. Page 3, the judgment starts at the last bottom line by Justice Patil, if your lordships.
Paragraph?
Lord, it starts, my lord, bottom of page 4, page 5, on the top. Paragraph 1. What was the issue before the Constitutional Bench? If the approval is not granted under section 33.
Yes, this is the question.
Yes, this was raised in the Constitution Bench.
Yes. So this is the only question.
That is the only question that was raised. I'll take your lordships to certain paragraphs. I'll just first read out that.
Yes.
If the approval is not granted under section 33(2)(b) of the Industrial Disputes Act, whether the order of dismissal becomes ineffective from the date it was passed.
Exactly.
So it has already been passed and he is out of employment. So 33(2)(b), if it is disapproved, then what will be the natural consequence of such disapproval?
Right.
So the action has to be
in
taken.
fact, this was the question which I was going to put right now.
Yes.
That what would be the consequence if the decision which you take is not approved?
Not approved. Then he will be deemed that he is continuing in employment. But my lord, as I was pointing out yesterday before lordships, that this is not that I have to take the permission first.
No, that is not there. It is not there. When you take an action, that will be subject to.
Yes, that approval.
That shall be subject to approval.
Approval. Now, what is the under 33(2), my lord, 2(b), what is the scope of that approving adjudication?
Right.
Lord, I'll take your lordships to that. May I take your lordships to the first
Yes.
statute, my lord, section 33(2)(b).
That is also quoted here. Quoted here in this judgment.
In this judgment. Yes, my lord, that has been quoted. Lord, in context of that, I'll come to the certain paragraphs of the Constitution Bench judgment. Then I'll come to the, my lord, subsequent judgment, which I showed or I was explaining before your lordships yesterday, and our own High Court's coordinate bench judgment. Your lordships may come to section 33. Lordships, Lord.
The language of the proviso is so clear.
Yes, my lord, no, my lord, the small
Let us see what
difference.
the judgment says.
Yes, I'll come to that. If your lordship should come back to the same judgment that I was just showing, my lord, Constitution bench judgment. If your lordship should come to para 6. That is at internal page 4, my lords. In the same page where the reference has been made, the first paragraph, the reference, same page, para 6.
Yes.
Answer to the question which conflicting decisions are rendered, as noticed above, depends on the fair reading and proper interpretation of section 33(2)(b) of the Act. Prior to the amendment of 1956, the provision contained in section 33 corresponded to the present section 33(1) only. The object behind enacting section 33 as it stood before it was amended in 1956 was to allow the continuance of industrial proceedings pending before any authority, court, tribunal prescribed by the Act in a peaceful atmosphere undisturbed by any other industrial dispute. In course of time, it was felt that unamended section 33 was too stringent, for it placed a total ban on the right of the employer to make any alteration in condition of service or to make order of discharge or dismissal, even in cases where such alteration in conditions of service or passing of an order of dismissal or discharge was not in any manner connected with the dispute pending before an industrial authority. It appears therefore section 33 was amended in 1956, permitting the employer to make changes in condition of service or to discharge or dismiss an employee in relation to matters not connected with the pending industrial dispute. At the same time, it seems to have been felt that there was need to provide for some safeguards for a workman who may be discharged, dismissed during the pendency of a dispute on account of some matter unconnected with the dispute. This position is clear by reading the redrafted expanded section 33 in 1956 containing 5 subsections. For the present purpose, we are concerned with the proviso to section 33(2)(b). My lord, then the proviso has been noted. Then, my lord, para 7. The proviso expressly and specifically states that no workman shall be discharged or dismissed unless he has been paid wages for 1 month. Not that he is in continuous employment and he gets every month's wages. So that is like a notice pay.
There are two preconditions.
Yes.
One, that 1 month's wages is paid.
Should be paid and an
two,
application.
An application is made.
Yes.
So that's all.
Yes. So subsequent after that, my lord, based on judgments, because this was also even too narrow a proposition which was given in 33(2)(b). So to expand the adjudicatory process, certain other things were added to it where the court can see if it is a decision which has been taken for the purpose of victimization or unfair labor practice on a prima facie basis. That has been added subsequently in 33(2)(b) by judgment made law. There is no amendment or anything in the my lord, statute per se. So after that, my lords, your lordships might come to para 14. Page 8 of that judgment.
Yes.
Lord, 33 says about the mandatoriness of the proviso. Para 14 says, where an application is made under section 33(2)(b) proviso, the authority before which the proceeding is pending for approval of the action taken by the employer, that means the action has already been taken, has to examine whether the order of dismissal or discharge is bona fide. So this is the addition on the basis of this judgment of the Constitution Bench. Whether it was by way of victimization or unfair labor practice. whether the conditions contained in the proviso were complied with or not, etc. So this was the addition in the process of examination while granting the approval. The prima facie view has to be made that this is not by way of any victimization. If the authority refuses to grant approval, obviously it follows that employee continues to be in service, as if the order of discharge or dismissal never had been passed. The order of dismissal, discharge passed invoking 33(2)(b), dismissing or discharging an employee, brings an end to the relationship of the employer and employee from the date of his dismissal or discharge. But that order remains incomplete and remains incoherent as it is subject to approval of the authority under the said proviso. In other words, this relationship comes to an end de jure only when the authority grants approval. So till such time, it's a de facto, my lord, partition of service or partition of the relationship between the two parties, the employee and the employer. But de jure is only after the approval is given, because that will date back to the day when the action is taken. Similarly, if it is disapproved also, it dates back to the day when the action is taken, he will be deemed to be continued. If approval is not given, nothing more is required to be done by the employee, as it will have to be deemed that the order of discharge dismissal had never been passed. Consequence of it is that the employee is deemed to have continued in its service, entitling him to all the benefits available. This being positioned, there is no need of a separate or specific order for his reinstatement. But on the other hand, if the approval is given by the authority and if the employee is agreed by such an approval, he is entitled to make a complaint under section 33 capital A, challenging the order granting approval on any of the grounds available to him, which will be a comprehensive adjudication where evidence will be taken so far as my action, my evidence which has been laid, whether the adequacy of evidence, everything has to be taken under 33A, which is akin to a reference as it is made if in case of an employee who is not connected with the dispute. So like if there is no 33(2)(b) application in person or in respect of an employee who is dismissed in a normal course where there is no pending dispute or anything, he raises a dispute under section 10(1) or 2A2 as is available to him. Then the reference will be answered. So the adjudicating power under 10(1) is akin to section 33 capital A, which is more like an appeal against that order, but before the same authority. Section 33A is available only to an employee and is intended to save his time and trouble inasmuch as he can straightaway make a complaint before the very authority where the industrial dispute is already pending between the parties, challenging the order of approval instead of making efforts to raise an industrial dispute, get a reference, and thereafter adjudication. In this view, it is not correct to say that even though where the order of discharge dismissal is inoperative for contravention of the mandatory conditions contained in proviso or where the approval is refused, a workman should still make a complaint under section 33A. And the order of dismissal or discharge becomes invalid or void only when it is set aside under section 33. So what the Supreme Court stated that if the approval is not granted, then again he doesn't have to make a complaint under 33A, because that will become inoperative. As such, the termination will go. So it has to date back. But if it is approved and the action of the management is upheld, then only the complaint shall be filed only by the employee, right, not by the employer even.
Employer has...
Because this is more of a, I would say, not beneficial, but proactive legislation to support or to avoid victimization of the employees. Then your lordships, I'll take your lordships to another judgment of this Honorable High Court. Then under 33(2)(b), what is the adjudicatory power? My lord, I was showing yesterday to your lordship the 2019 Supreme Court. I'll just, Lord, prior to that, I'll come back to it again. Our own High Court judgment, division bench judgment, my lord.
Can we take up the matter again at 2 p.m.?
Absolutely.
You're not able to consider another case for the claim will be 2 p.m. I will
that. So maybe taken up at the second, so that I can compare them.
May I pray, madam? I am appearing in item number 39. It is a very urgent matter only. Already there is a jaundice spreading in Kotak city, madam. Right?
Already?
Jaundice. Jaundice is spreading in
No,
Kotak.
but we have constituted a division
This
bench.
is also same, but how it is listed.
So
here.
this matter shall be listed along with that.
Is a part-heard matter. This bench
There
has
is
already
no
been
part
heard.
heard.
It is also part.
No matter is parted. We have, I have constituted a bench for that
Well,
purpose. So we
Did
will see.
I mention before that bench that another case is also coming? from-
No, that matter is,
Today, at two.
is being taken up today.
Yes,
So we can send this case also.
yes.
All right.
Your lordship so pleases, but this
So
matter,
notify kara do.
but this matter
This
is.
this, please go before that bench.
My lord.
Argue your matter, the matter shall be identified, shall be notified before that bench. All right?
Today-
Happy? Yes, yes, today.
Yeah, 2 p.m.
2 p.m.
Item 28.
Lord, I'll just take back your lordship to the judgment that I had shown yesterday, madam. The 2019 John D'Souza case versus Karnataka State Road Transport Corporation. That is 2019, volume 18 SCC, page 47. Given a copy.
68. Digital page 168.
Yes, 2019, volume 18, you were showing this.
Yes. 18 SCC, page 47. Yesterday I had shown only the, my lord, concluding portion. I'll just give the legislative intent of 33 to B also. The lordships may come to para 13. Which is at internal page 9 of that judgment. In the journal, it would be
Yes.
page 56.
Yes.
Lord, para 13. Before determining the width and length of jurisdiction exercisable by a labor court or tribunal under section 33 to B, it is beneficial to discuss the legislative scheme of the Act and some of its relevant provisions having a bearing on the issue to be resolved. 14. The 1947 Act was enacted to remove the defects experienced in the working of the Trade Disputes Act 1929 and to provide inter alia statutory mechanism for the settlement of industrial dispute, which is conclusive and binding on the parties to the dispute, to check the industrial unrest, for creation of 2 new institutions of works committees and industrial tribunal, to provide an explicit procedure for reference of an industrial dispute by the appropriate government and enforcement of the award which may be passed, to reorient the administration of the conciliation machinery provided under the old Act, and also prohibition on strikes, lockouts during the pendency of conciliation and adjudication proceedings, etc., etc. The Act therefore unambiguously aims at harmonizing the management-workman relationship and to prevent labor unrest or industrial peace, both being detrimental to the industrial growth of the nation. Then your lordships may come to para 18.
Yes.
Lord, para 18. Lord, at para 17, the section 11A has been given, and 11A, which was inserted later on, that has been discussed. Section 11A of the Act unequivocally empowers the labor court tribunals and national tribunals to set aside the order of discharge or dismissal of a workman and direct his reinstatement on such terms and conditions as it thinks fit, or to award any lesser punishment in lieu of such discharge or dismissal, provided that the labor court or the tribunal, as the case may be, is satisfied that the order of discharge dismissal was not justified. So this exercise of power to change the punishment is only under section 11A, and that is only in an issue where the reference is made under section 10(1) or subsequently by the amendment of 33 capital A. So far as the other provisions are concerned, 11A cannot be made applicable to it. Next, my lord, the chapter 7 of the Acts comprises miscellaneous provisions, and its section 33 provides that condition of service, etc. of the workmen shall remain unchanged in certain circumstances during pendency of proceedings. Section 33(2), with which we are concerned, reads as follows. Then the section has been quoted. Then your lordships may come to para 20. The composite scheme of the statute bears out that when an industrial dispute pertaining to discharge or dismissal of workmen, including reinstatement of or grant of relief to workmen wrongfully dismissed, arises, such dispute is referable for adjudication to the labor court in exercise of jurisdiction vested in it under section 10(1)(c) of the Act. The labor court shall have the powers of the civil court to secure evidence for deciding such dispute. Most importantly, the doctrine of proportionality is statutorily embedded in section 11A of the Act, which further empowers the labor court, subject to its satisfaction, to set aside the order of discharge or dismissal and reinstate a workman on such terms and conditions as it thinks fit, or to award a lesser punishment in lieu thereof. All such awards or orders are enforceable under the Act. This legislature has thus provided self-contained mechanism through section 10, read with section 11(3) and 11A of the Act, for adjudication of an industrial dispute stemming out of an order of discharge or dismissal of a workman. Having done so, it can be safely inferred that neither the legislature intended nor was there any legal necessity to set up a parallel remedy under the same statute for adjudication of the same industrial dispute by the same forum of labor court or tribunal via section 33(2)(b) of the Act. To say it differently, section 33(2)(b) has been inserted for a purpose other than that for which section 10(1)(c) and D have been enacted. Section 33(2)(b) thus is neither meant for nor does it engender an overlapping procedure to adjudicate the legality, propriety, justifiability, otherwise sustainability of a punitive action taken against a workman. Having held so, it should not take long to trace out the legislative object behind incorporation of Section 33, including 33 subsection 2 thereof. The caption of Section 33 itself sufficiently hints out that the preliminary object behind this provision is to prevent adverse alteration in condition of service of a workman when conciliation or any other proceeding in respect of an industrial dispute to which such workman is also concerned are pending before conciliation officer, board, arbitrator, labor court, or tribunal. The legislature, through Section 33(1)(a) and (b), has purposefully prevented the discharge, dismissal, or any other punitive action against the workman concerned during pendency of the proceeding before the arbitrator, labor court, tribunal, even on the basis of proven misconduct, which is proven in a domestic inquiry, save with the express permission or approval of the authority before which the proceeding is pending. Subsection 2 of Section 33 draws its color from subsection 1 and has to be read in conjunction thereto. Subsection 2, in fact, dilutes the rigors of subsection 1 to the extent that it enables an employer to discharge, dismiss, or otherwise punish a workman for a proved misconduct not connected with the pending dispute, in accordance with the standing orders applicable to the workman or in absence thereof as per the terms of the contract, provided that such workman has been paid 1 month wages while passing such order and before moving application before the authority concerned for approval of the action. In other words, the authority concerned, that is board, labor court, or tribunal, has to satisfy itself with, while considering the employer's application, that the misconduct on the basis of which punitive action has been taken is neither the subject matter sub judice before it, and that the action has been taken in accordance with the standing orders in force or as per the terms of the contract. The laudable object behind the preventive measures is to ensure that when some proceeding emanating from the subjects enlisted in 2nd or 3rd schedule of the Act are pending adjudication, the employer should not act with vengeance in a manner which may trigger the situation and lead to further industrial unrest. So that is how the distinction was brought about between 33(1) and 33(2).
Observations are directly against you.
My lords?
These observations are directly against you.
No, my lord, the explanation I'll give, my lord, so far as the punishment, punitive effect of it comes. Because here we are concerned, I'll come to the award also, where he has held that the inquiry is fair and proper.
He cannot enter into that.
No, he can. My lord, that is why the limitation is there, my lord. That is why, my lord, I said 33(2)(b) is different, my lord, little different from the other provisions.
Yes, sir.
Section 33(2)(b) of the Act, my lord, para 23.
Yes.
Thus, in the very nature of things, contemplates an inquiry by way of a summary proceeding as to whether proper domestic inquiry has been held to prove the misconduct so attributed to the workman and whether he has been afforded reasonable opportunity to defend himself in consonance with the principles of natural justice. As a natural corollary thereto, the labor court or the forum concerned will lift the veil to find out that there is no hidden motive to punish the workman or an abortive attempt to punish him for a non-existent misconduct. The labor court tribunal, nevertheless, while holding inquiry under Section 33(2)(b), would remember that such like summary proceedings are not akin or at par with its jurisdiction to adjudicate industrial dispute under Section 10(1)(c) and (d) of the Act, nor the former provision clothe it with the power to peep into the quantum of punishment for which it has to revert back to Section 11(a) of the Act. Where the labor court tribunal thus do not find the domestic inquiry defective and principles of fair and just play has been adhered to, they will accord the necessary approval to the action taken by the employer, albeit without prejudice to the right of the workman to raise an industrial dispute referable for adjudication under Section 10(1)(c) or (d), as the case may be. It needs pertinent mention that an order of approval granted under Section 33(2)(b) has no binding effect in the proceedings under Section 10(1)(c)(d), which shall be decided independently while weighing the material adduced by the parties before the labor court tribunal. then, my lord, here the complete distinction has been given. The authority of the court so far as it relates to the adjudicating powers under section 33(2)(b). Then, my lord, again at para 30, which is internal
Please
page
come
6.
to paragraph 26,
Yes, please.
where PNB case has been referred to.
Yes, 3-judge bench of PNB.
Yes.
The workman considered and interpreted the scope of section 33 to lay down that the jurisdiction of the tribunal dealing with applications is limited. It was held that when an application is made,
Yes.
I'm sorry, my lords.
Paragraph 24, which is quoted.
Yes, where an application is made by the employer for the requisite permission under section 33, the jurisdiction of the tribunal dealing with such an application is limited. It has to consider whether a prima facie case has been made out by the employer for the dismissal of the employee in question.
That is the most significant
Yes.
observation.
Observation.
That it has to, in the background of facts of the present case,
Present case.
that it has to consider whether a prima facie case has been made out
Made out.
by the employer. So the labor court is of the opinion that the court has referred to the conduct alleged against him and says that dismissal or discharge.
That he cannot, that punishment portion he cannot tinker with.
He does not say anything. The labor court says that this is disproportionate. Dismissal of the employee.
Disproportionate is the quantum of punishment.
No question of quantum of punishment. The
Whether it
question
should
is
be a
whether
dismissal.
dismissal should be approved or not. He says dismissal cannot be approved.
So he should have rejected on the basis that the domestic inquiry was fair or proper or not. Once he holds that it has been done fairly and properly.
No. It says whether prima facie case has been made out by the employer for dismissal of the employer.
Yes, my lord, that he has given the, my lord, in the impugned order. He has written that.
So therefore,
I'll come to that, my lord.
and in fact that
once he comes to a finding that there is no disproportionality or there is no victimization or anything, he cannot say that instead of this you reduce the punishment.
He is not asking you to reduce.
Yes, my lord, that is what the directive.
To that extent, it may be, if there is any direction to that.
And my lord, this judgment of PNB was prior to the amendment. 1960 Supreme Court was prior to the amendment, and which has been, my lord, subsequently dealt with in this very case also. If your lordships would see, the judgment is of AIR 1960 Supreme Court page 160. That was prior to the amendment of section 33 when the 33(2)(b) was introduced.
Yes.
Earlier it was only 33(1).
Yes.
Where it was necessary that there has to be a previous my lord, approval.
Right.
So this judgment per se, my lord, in 33(2)(b) cases, this cannot be made applicable because the statute was not there at that point of time. That's why, my lord, I had taken your lordships to page, my lord, para 30. Lordships got that?
Yes.
This court in the above cited decisions in no uncertain terms divided the scope of inquiry by the Labour Court Tribunal while exercising jurisdiction under section 33(2)(b) in two phases. Firstly, the Labour Court Tribunal will consider as to whether or not a prima facie case for discharge dismissal is made out on the basis of the domestic inquiry if such inquiry doesn't suffer from any defect, namely, it has not been held in violation of principles of natural justice and the conclusion arrived at by the employer is bona fide and there was no unfair labor practice or victimization of the workman. This entire exercise has to be undertaken by the Labour Court Tribunal on examination of the record of inquiry and nothing more. In the event where no defect is detected, the approval must follow. The second stage comes when the Labour Court Tribunal finds that the domestic inquiry suffers from one of the other legal ailment. In that case, the Labour Court Tribunal shall permit the parties to adduce their respective evidence, and on appraisal thereof, the Labour Court Tribunal shall conclude its inquiry whether the discharge or the other punishment, including dismissal, was justified. My lord, then I take your lordships to para, my lord, then the judgments have been discussed. Para 37. May I please?
Yes.
Para 37. The Labour Court or the Tribunal, therefore, while holding inquiry under Section 33(2)(b, cannot invoke the adjudicatory powers vested in them under Section 10(1)(c) and (d) of the Act, nor can they, in the process of formation of their prima facie view under Section 33(2)(b, dwell upon the proportionality of the punishment as erroneously done in the instant case, for such power can be exercised by the Labour Court or Tribunal only under Section 11A. Consequently, the Labour Court shall, in the instant case, revisit the matter afresh within the limit and scope of Section 33(2)(b, as explained above, and keeping in that the exercise in hand is not adjudication of an industrial dispute under Section 10(1)(c) or (d) read with 11A of the Act. However, if the Labour Court finds that the domestic inquiry held against the appellant is suffering from one of the incurable defects, as illustrated by this court in Mysore Steel Works Private Limited and Lalaram case, which is regarding that proviso, my lords, these two cases, then it may look into the evidence adduced by the parties for the formation of its prima facie opinion.
Yes.
Then I take your lordships to the division bench judgment of this honorable court. I've given, my lord, if your lordships have it, that is 1991 to OLR 515. Which is OJC number 33750.
1990.
To OLR, 1991 volume 2 OLR, page 515. That is OJC number 3375 of 1990. I had given the judgment copy earlier also.
Just.
Yes.
What is it? What is it? What is it?
ORTC. ORTC versus the workman Bengali Patra and others. Para 4 of that judgment.
Page.
That is, my lord, internal page 3 of that.
No.
208.
Yes.
The lordships may come to internal page 3 of that judgment, para 4. Starts with coming to the first submission.
Yes.
Lord, your lordships may come to the next sub-para, the sole object. Because the section has been quoted after that.
Yes.
The sole object of Section 33 is to protect the workmen concerned in disputes which form the subject matter of pending proceedings against victimization by the employer on account of their having raised industrial dispute, and to ensure that the proceeding in connection with the industrial dispute already pending should be brought to a termination in a peaceful atmosphere. And no employer should take any action of the kind mentioned in the section which may give rise to fresh disputes likely to further aggravate the already strained relation between the employer and the workman. To achieve this objective, a ban subject to certain conditions have been imposed by Section 33 on the ordinary rights of the employer to alter the terms and conditions of his employees' services to their prejudice and to terminate their services under the general law governing the contract of employment. Section 33(2) clearly indicates that the punishment or of discharge or dismissal will be subject to the proviso. Under the proviso, therefore, the employer can still exercise his right of discharging or dismissing an employee, subject to the condition that the employee concerned should be paid wages for 1 month and an application should have been made by the employer to the appropriate authority for approval of the action taken by the employer. The scope of inquiry in an application under Section 33(2)(b) is to find out whether a proper domestic inquiry in accordance with the relevant rules or standing orders and principles of natural justice has been held, and whether a prima facie case for dismissal based on legal evidence adduced before the domestic tribunal is made out. And lastly, whether the employer had come to a bona fide conclusion that the employee was guilty and the dismissal did not amount to unfair labor practice and was not intended to victimize the employee. On being satisfied with the above aforesaid test, the tribunal should accord approval, which would, of course, relate back to the date on which the employer ordered for dismissal. The nature of jurisdiction exercised by the tribunal while according approval under Section 33(2) is therefore limited. When the tribunal gives or refuses to give permission, it does not adjudicate an industrial dispute. Thus, an industrial tribunal has no jurisdiction while deciding an application under Section 33 of the Act to consider whether the punishment sought to be meted out by the employer to the workman is harsh or excessive, or to substitute another punishment, or to impose any conditions on the employer before the requisite permission could be granted, whereas the power of industrial courts, my lord, that should be industrial, I think some words are missing, industrial courts and labor court under Section 10(1)(d) read with Section 12(5) of the Act is quite extensive, and the main object of the tribunal is adjudication of the dispute. The legislature, by introducing Section 11(a) of the Act, has now given power to tribunal to satisfy itself whether the misconduct alleged is proved or not, and even if it has the power to interfere with the punishment imposed by the employer. In other words, the power of the tribunal lies to differ from the management both on finding of misconduct arrived at as well as punishment imposed by it. Such being the power of tribunal in a reference under Section 10 read with Section 12(5) of the Act, which is quite distinct from the power of tribunal under Section 33(2), when an application for according approval to act, order of discharge or dismissal is made, it is difficult to accept the contention that an order of tribunal approving an order of discharge or dismissal under 33(2)(b) would make a subsequent reference under Section 10 incompetent. So that was on the different issue whether the subsequent 10(1) reference can be made or not. But so far as the punishment is concerned, now I take lordships to the impugned award. Impugned order, in fact, my lord, 33(2)(b) order. If your lordships would come to running page 17 of the brief, my lords.
Yes.
My lord, just for a moment, if I take your lordships to page 16, the last two lines, para 5. The issues which were framed. Lord, that is page 16 of the brief.
Yes.
Para 5, the last three lines, my lord, of that
Yes,
page.
yes.
While dealing with the application on Section 33(2)(b) of the ID Act, the court has to consider two things. One, whether the workman was dismissed from service on the basis of domestic inquiry conducted observing all formalities without violation of principle of natural justice, whether the punishment of dismissal of the workman was commensurate to the acts of misconduct level against him, which in my respectful opinion, my lords, that the court could not have done. Then he comes, my lord, he says in the last portion of that, last three lines, considering the materials available on record and discussions made above, I have no hesitation to hold that the domestic inquiry conducted by the management was fair and proper. Then the next, my lord, page 6, my lord, page 18, para 6 and 7, which is impugned, my lord, and the directive portion. So far as the legality of the punishment is concerned, I find that the allegation against the workman is that on so and so date he did not perform so and so, my lord, which resulted in loss in production. The losses may come to he has not, which starts mid of the, my lord, para 6, little after mid. He has not directly caused any loss. So to justify his direction, he has not directly caused any loss to the company, and therefore the punishment of dismissal from the service of the workman, in my considered opinion, was not commensurate to the acts alleged against him. It doesn't say I have victimized or there is unfair labor practice. I have not followed the principles of natural justice. No violation of the proviso that I have not given the notice pay or I have not filed the application. No defect has been found. But he comes to the conclusion. So then he gives a directive, the management should impose some lesser punishment on the proof of charge level against him. Then taking into consideration the materials available on record and discussions made above, I am inclined to hold that the punishment of dismissal imposed by the management upon the workman was improper and unjustified. So that, my lord, in my respectful submission, 33(2)(b) doesn't permit it.
Yes.
He may say that my action is bad by whatever the principles of the law or whatever my action in doing the domestic inquiry was not fair, proper, I have not followed the proviso, or there is a victimization, then victimization has to be proved. There's an unfair labor practice that has to be proved. But nothing has been, not a single word has been spoken. And he comes to a conclusion that I feel it is not commensurate. Where, my lord, this honorable court had just shown your lordship, the Supreme Court as well as this honorable court has said that he cannot personally replace the punishment or suggest a lesser punishment or a different terms of the punishment. So that is, on that basis, he said that the application 33(2)(b) is rejected. So, my lord, my respectful submission before lordships is that he has overreached his power, which is, he is empowered under 33(2)(b), which restricts the exercise of adjudicatory process or powers to finding out certain technical issues. It is not a trial per se where evidence has to be laid. It is a summary trial where the prima facie view has to be made out. So once he has come to a conclusion that my action has no mala fide behind it, my action is justified, then he cannot say that the punishment is disproportionate or should not be this or should be lesser. Or if less, what is less, my lord? If it can be a discharge simpliciter instead of dismissal, which may permit them certain benefits so far as the employment is concerned.
No, that is not the idea. It's a question of only either approval or
disapproval.
not approval, disapproval. So whether while doing that exercise, applying the doctrine of proportionality, the labor court could have done that or not. The Supreme Court, you are right. And the specific terms in paragraph 37 of that is
38, 37 and
37
clearly say
it cannot be done. You are right there in your submission. And it will be very difficult for him to.
No, my lord. My only endeavor is to assist, and I also tried as a
difficult for him. We decide. We don't have any difficulty. Our difficulty is that you argued the matter on May Day, and we may be discussing his allowing your writ petition.
No, my lord. And your lordship, like last, as I pointed out yesterday, I also tried. I spoke to the director level, but the only problem is they said, sir, this will create a very bad precedent for the persons who were involved in the brutal killing of an employee and officer.
That would not have weighed in our minds. The law, yes, we cannot go contrary.
No, we cannot.
Howsoever, still we attempted. No question of allegation. It's a question of limitation. So whether the limitation, in fact, initially I was also of the view, and speaking for myself, that while doing that exercise, the labor court could have disapproved the order of discharge on the opinion that this order should not have been passed. All right. So any other punishment could have been imposed, but this punishment ought not to have been imposed and could have declined on that ground. But in view of the clear observation made by the Supreme Court, that observation does not leave any scope for further interpretation of that provision. So nothing can be done. And what happened to your dispute? The earlier, there was one dispute pending. What happened in that case? What happened?
That those disputes were dismissed for default because most of them are absconding. Their office bearers ID case, that original ID case which was pending. So that has no relationship. That was basically regarding the certain service conditions, higher rate of wages, and all those things were involved. There are 4 charter of demands. So on that basis, the dispute was going on. Here it was a purely case of misconduct where the inquiry was held, which had no direct.
No, but again, a fresh order will have to be passed by the labor court.
As your lords.
No, suggest us, what should we do? We cannot just set aside the order without giving
any reasoning and remind it back.
No. An
Lord,
order.
reasoning means without giving any opinion on.
We cannot approve. We cannot approve your dismissal. So.
No, it has to be done by the authority concerned.
By the authority.
Yes, ma'am. That I agree.
So for that reason only, if we remand the matter back. What can be done?
To that limited extent, your lordships can always.
So we will have to allow. We don't have any. We wanted some. In fact, even the Supreme Court in that case, in 2018,
remanded back.
18, not remanded back. In fact, the Supreme Court referred the matter to mediation if we are not incorrect.
Mediation, yes.
Huh? Mediation for resolution of. Difficult. But here, since the management has taken a stand.
Lord, we tried for that financial also, if anything could be given instead of re-employment or anything. They were very firm that since Lord.
No re-employment, just some compensation.
Yes, that is exactly what they said. If we do it from our side and we agree to that proposal, then my lord, it will create a bad precedent because people will act like that again. And they might say that we go back to the court and we get some benefit out of it. Because the action taken by them was of such nature where, Lord, it was also difficult on my part to also convince them because when their chief executive officer who was in control of the factory was.
Yes.
The last item you will see, that is allegation only.
How many cases are there?
Three cases.
He was found during work, he was sleeping.
Mister, the whole difficulty is that can be a subject matter of separate, full-fledged industrial dispute, but not and the order has been passed in all the 3 cases.
All the 3 cases.
Same order.
Almost identical order. My lord, there's a slight variation, but in material terms, it's almost the same.
Like we are. मैटर फिक्स है क्या बोल all right. The petitioners, petitioner one, the petitioner. So and so bracketed management has put to challenge an order dated 6/6/2012 passed in miscellaneous case number 2 of 2012 by the presiding officer, Labor Court, whereby an application filed by the management under section 33 bracketed 2 bracketed B of the Industrial Dispute Act for dismissing the
Let's say
approval of an
rejecting, the disapproval, approval application was rejected. It was not a dismissal because that is the word approval or rejection was rejected.
Just an application for approval of an order of dismissal has been rejected. So next, we have heard learned senior counsel representing the management and learned counsel representing the workman. Full stop. During the pendency of an industrial dispute and a disciplinary proceeding was initiated against the respondent by the management which subsequently led to passing of an order of dismissal by the management. Full stop. Section 33 bracketed 2 bracketed B of the Act mandates that during the pendency of any proceeding in respect of an industrial dispute, comma, the employer may in accordance with the standing orders applicable to a workman concerned in such dispute, alter
the conditions of service applicable to the workman immediately before the commencement of the proceeding or for any such misconduct not connected with the dispute, discharge or punish, whether by dismissal or otherwise, that workman. Full stop. The proviso to subsection 2 clause B of subsection 2 of subsection 2 of section 33 is at the core of the controversy in the present case, which reads thus. Full stop. A bare reading of the aforementioned proviso, it can be discerned, easily discerned, that there are two condition precedents for discharge or punish by dismissal or otherwise a workman during the pendency of a conciliation proceeding before a conciliation officer. That is the that refers to before the during the pendency of conciliation proceeding.
No, my lord, during the adjudicatory proceeding of the ID case, which is, my lord, mentioned, ID case number 11 of 2008 to 18 of 2008 at page 15 of the brief, if you lordship. So it's the first paragraph of the order. Or any other proceeding before the labor court tribunal or the same authority.
All right. Okay. Workman in exercise of workman in accordance with on bare refusal on bare refusal of the affirmative of a dispute of an industrial dispute, namely, (1), the workman is paid wages for 1 month. 2, 2, an application has been made by the employer to the authority before which the proceeding is pending, semicolon, for approval of the action taken by the employer. या for से लेकर employer तक वो underline कर दोगे, bracketed underline for
emphasis. Full stop. The facts of the case are not in dispute. The respondent, opposite party, the opposite party, while working as a technician, arc furnace, what is this? Arc furnace.
Tester in stores department.
Technician arc furnace in SMS department. The respondent, comma, a workman, was charge sheeted by the management on 1/8/2009 on the charge of misconduct of refusal to work and negligence in discharge of the duties. Comma negligence karo. Comma participating in illegal strike and willful disobedience to the lawful orders of the superiors. Full stop. The workman was found to be guilty of misconduct in an inquiry held by the management, and considering the seriousness of the charge, proposed to impose punishment of dismissal. In accordance with the provisions under the standing orders. Provisions under the standing orders of the company bracketed the management. Stop. The opposite party was given an opportunity to reply against the proposed punishment. Stop. Later, comma, he was dismissed from service with effect from 3/3/2011. Stop. That dismissal had given rise to industrial dispute.
No, man. Industrial dispute was earlier. That was a pending, which was regarding certain service conditions and charter of demands made. So that was the original dispute which was pending.
What is that? What is that? Where is that?
That is ID case number in the first para of the page 15, where the order, impugned order is there, if your lordships can.
Where is that?
Page 15, first paragraph, my lord, ex parte order, this order. So in ID case number 11 of 2008 to 18 of 2008.
Stop. It is noted that when the said order of dismissal was passed by the management, comma, and this industrial dispute was pending in ID case number 11/2008. What was his case? 11/8/2008 to.
There is no case because he was not concerned with the dispute. He is unconnected. That was by the union regarding several service conditions. That is why 33(2)(b). Otherwise, it would have been 33(1).
11/2008 to 18/2008. Stop. It transpires from the order sheet, from the impugned order passed by the presiding officer, Labor Court, Sambalpur, Labor Court, Sambalpur, that it is not in dispute that the management had complied with the requirement of payment of wages for 1 month and filing of and making of an application to the labor court for approval of action of workman's dismissal from service. The labor court, in its impugned order, has noted in paragraph 5 that while dealing with an application under section 33(2)(b) of the ID Act, the labor court has to consider two things, namely, A, whether the workman was dismissed from service on the basis of domestic inquiry conducted observing all formalities without violation of principles of natural justice, and B, whether the punishment of dismissal of workman was commensurate to the acts of misconduct leveled against him. Stop. As regards the next, as regards the first consideration, the labor court found that there was found based on the evidence adduced before him that the inquiry was conducted observing principles of natural justice and due opportunity was given to the workman to defend the charge level against him. So stop. The Labor Court specifically recorded that the report of the inquiry officer was based on the evidence collected during the inquiry, and there was nothing to find any fault in the report. So stop. The Labor Court went on to record that the domestic inquiry conducted by the management was fair and proper. Stop. Next, however, considering the second aspect of the matter, however, considering the second point, that is whether the punishment of dismissal of workmen was commensurate to the acts of misconduct or not, the Labor Court reached a conclusion that the management ought to have imposed some lesser punishment on the proof of charge level against him, comma, instead of dismissing him from service. Stop. He recorded this finding in the wake of the fact that the workman was charged of not performing his duties on 5/7/2009 with other workmen in protest of an alleged assault to a regular workman. Stop. The Labor Court noted in its impugned order that the workman had not initiated any strike, nor had he called for a stoppage of work, but he had only responded to the call for refusal of work on a particular cause. Full stop. According, full stop. Further, comma, he had not directly caused any loss to the company, and therefore punishment of dismissal from service of the workman was not commensurate to the acts alleged against him. Stop. After having opined thus, the Labor Court rejected the management's application filed under section 33 bracketed 2 bracketed B of the Act, holding that the management's action in dismissal of the workman from service with effect from T3/2011 could not be approved. Stop. Assailing the impugned order of the Labor Court, learned senior counsel appearing on behalf of the management has drawn our attention to various decisions of the Supreme Court, including following decisions of Supreme Court, colon dash, Tata Iron and Steel Company Limited versus SN Modak, bracketed AIR 1966 SC 380. Jaipur Jila Sahkari Bhumi Vikas Limited versus Ram Gopal Sarma and others, reported in 2002, Volume 2, SCC 244, and 2019. उसका party name लिख लो. Volume 18 SCC, page 47. So he has also placed reliance on a division bench decision of this court in case of so and so, reported in 1999, Volume 2, OLR 515. 1991, Volume 2, OLR 515. So stop. Explaining the scope of limitations and scope of the power of a labor court while considering an application under section 33 bracketed 2 bracketed B of the ID Act with reference to aforementioned decisions, he has submitted that it was not within the jurisdiction of the labor court to enter into the proportionality of the punishment imposed by an employer imposed by the management during the pendency of an industrial dispute. Full stop. He has laid great emphasis on the law laid down by the Supreme Court in case of 2019, Volume 18, SCC. Paragraph 37 of which reads thus. So stop. Next. The Supreme Court's decision in case of so and so. Next. Learned counsel appearing on behalf of the workman has submitted that that duly exercising its jurisdiction, its power under section 33 bracketed 2 bracketed B of the ID Act, the labor court declined to approve the order of dismissal passed by the management, which was not found to be bona fide, comma, the same being shockingly disproportionate to the charge of misconduct. So stop. He has submitted that the impugned order passed by the presiding officer, Labor Court, does not suffer from any legal infirmity. So stop. Next. After having carefully gone through the impugned order passed by the Labor Court and the Supreme Court's decisions, as noted above, more specifically, comma, the law clearly enunciated in case of so and so. What is the party name? 2019? Case of 2000.
John D'Souza versus
John,
Karnataka State Road Transport Corporation.
comma, we find force in the submission advanced on behalf of the management. So stop. Which page is that? 16. Next, in case of John D'Souza versus Karnataka State Road Transport Corporation, the Supreme Court has noticed the judicial pronouncements on the limitation, scope, and nature of exercise of power by a labor court under section 33 bracketed 2 bracketed B of the ID Act. So stop. After having noticed the precedents and the statutory provisions, the Supreme Court has held in no uncertain terms in paragraph 37 so next, in view of the law laid down by the Supreme Court in case of so and so John D'Souza, to the effect that a labor court or tribunal exercising while holding an inquiry under section 33 bracketed 2 bracketed B of the ID Act cannot invoke cannot dwell upon the proportionality of punishment, comma, we have no other option but to interfere with the impugned order passed by labor court so and so Sambalpur, impugned order dated so and so. Stop. The said order is accordingly set aside. So stop. The labor court, so and so shall be required to pass an order afresh on the management's application filed under section 33 bracketed 2 bracketed B of the Act. Preferably within a period of 3 months from the date of receipt or production of a copy of this order. Stop. This application is allowed with the aforesaid observation.
In the other two cases, only the nature of misconduct has to be changed. That's all. Rest all, my lord, on the legal issue, it's identical.
Nature of misconduct. How can we do that?
Lord,
Nature of, can you provide us?
the
Give us. Huh?
it will
Just give us.
Yes.
Nature of misconduct.
The name in the department in which he was working and the nature of misconduct. DPO.
Yes, but we feel very sorry.
Item number 29.
29, your lordships, this is one of the important PILs, which is monitored by the court. In fact, it's one of the listed PILs in our portal also. Basically, your lordships, this is a PIL where dealing with the leprosy colonies. Your lordships will find that there was one order dated 14/7/2021. Well, 14/7/2021, that would be order number 20.
Yes, it is there.
Yes, your lordships, in para 15, there was a committee of 3 amicus.
Paragraph 15.
15. That's when the court, for the first time, appointed a committee having 3 advocates in that. And we visited around 5 colonies, 4 in Puri and Khorda and in Balesur. And your lordships, then we have submitted time-to-time reports. Balesur was taken up as the model to be set up everywhere.
What is there in paragraph 15?
15 is, your lordships, we just wanted to show that how the whole thing started and the court started monitoring. So there was an appointment and with several directions were there as to how we go about.
No, I'm not finding.
Your lordships, it must be order dated 14/7/2021.
Yes, order dated for, oh, sorry. Yes. Yes.
Yes. It is at this stage that the court appointed a committee at para 15, and there were several directions.
Yes.
To ascertain the living conditions, medical facilities, and for around 3 places we went. And Balesur was one of those places where, if your lordships will be aware that pre-Britishers' time, there used to be a body called HKNS where Britishers had donated a lot of land. So it is a body under that. There was a huge land there. There was a hospital, leprosy hospital there. And also government had given some land for settling people there. it was in a very dilapidated condition. And their patients, almost one of them was dead by that time. And then the court took it up as a model to be set up everywhere. And a lot has happened. The government cooperated, the hospital was renovated, the several houses have come up, pathways have been built, even livelihood projects have been taken up. Thereafter, the whole thing was monitored, and last year summer, 3 more districts were chosen. One was Jharsuguda, Sambalpur, and Sundar. So Bargarh, sorry. So even there we gave certain reports. Meanwhile, the court also asked the government as well as 2 of the amicus to be present, and there is a whole-time committee which sits once a month, and reports are submitted as to how they are progressing. So the last meeting was on 15/4/2024. I think that report the government hasn't hasn't brought on record. 15/4.
Meeting is, minutes of the meeting is there, but that has not been put in form of an affidavit by the state government.
In fact, one of the concerns that we found, and in fact that's widely reported throughout India also, that most of these leprosy colonies historically came up over railway land. So even if the government wants to do a lot, the issue is, we put a suggestion, they've also accepted, that at least on a one-time basis to take it up with the railways so that, they are rehabilitated properly. Because once they don't have a proper land, the government is very interested to start with the housing project they have done. And some of the cleaning, some livelihood projects. So that is one, one of the suggestions we had given. But I think if that report comes on record, then your lordships will have an idea that how the court and the government and as all of us are working. And just to bring a little bit, we also went through all the policy statements which had come from the central government. So presently, leprosy is not treated as a separate disease. It's assimilated in the same hospitals. The same workers work. So in that setup, it is done. There are some ASHA workers who go there time to time, check them if there's new cases. And basically, it's a skin disease. So they lose their sensation. And so you will have to, do all sorts of, you take care of the wounds. Even they're trained also. The kits are also given. But the main issues that we found was most of them do get into begging because they have no alternative. So Baleswar has really come up. In fact, that meeting itself will show that that same kind of endeavor they're also making in different districts, like mushroom farming or weaving, so which they can do. And they've also trained now, as they've been staying there, so they've got married to each other also. So they have children. Their children are also extended certain benefits. So this is the whole background I wanted to just bring to your lordships. And I think the important thing is that report, if comes up, then maybe some directions.
So far as this report is concerned, I can find this not by an affidavit, and on the basis of their suggestion.
In fact, in such matters, there should not be any direction.
No. And so
we are saying something else. So you should rather, because it is public interest and the government is more interested, equally interested rather in public interest. Therefore, what we expect from you, you should do more than that.
Right.
So every month you rather, or whenever the matter is taken up, you should come forward to say that in the meanwhile we have done this.
Right.
There is no question of any direction. So this is how these matters should proceed.
Right.
This is one aspect. The other aspect is, though it is very difficult, it is to be decided, final decision will have to be taken by the government. Why separate housing?
There since long.
Housing, no, for them till they are suffering. It's a different matter. But why should they remain outcast throughout their life?
May I please, madam?
Just a minute. Let us understand this. So, all right. So what are you doing for their housing?
Housing has not come up, but my affidavit gets out of January. So far, children are concerned, we said that
scholarships and other things are also given to their children. And superlative and other, amenities that is being provided for.
What are you giving a scholarship?
Yes.
What will they do with scholarship?
Because the children are studying in schools,
Yeah.
in different schools, they are admitted to general schools, and they are studying there, and for them, special scholarship is also given, And for different districts, I filed an affidavit on 3rd of January 2024.
So whether the children are also suffering?
And most of the cases not.
So when the most of the cases are not suffering, then you should try to remove them from that. That.
Them into.
These
proper
historical
atmosphere.
places, like, we've met some couples, all those there are there on the video also, which we have submitted. Some of them don't even remember today where was their original place. In fact, I remember we interacting with a woman from Puri, and so the
She is suffering from.
He was. So once when she got it, they come and leave her there in Puri. So now she doesn't even remember where were her parents and who she was married to. Now she's living there. So the issue mainly is in Puri, in fact, we have two colonies. One which was from the missionaries, which is very well managed, and another one which in fact was in the railway. But now government, with the intervention of court, has rehabilitated them and is trying to take them back either to the missionary land, or there's another ashram that they're taking them back. So, and in fact,
the larger issue is of their integration.
Yes.
Right.
With
With the mainstream. That you can see, you can find out, you can identify a person suffering from leprosy, and you can take him and put in that ashram. That is one aspect. But what after that?
They get cured, or
they get cured, they should have.
Why these people are ostracized? Now, suppose the ancestors had leprosy, most of these colonies will be just outside the city. So they are remaining there. Now, since they come from a leprosy family, the society normally doesn't accept. So what falls on the lordship is something as a long-term measure, that's what Pankaj Sinha is all about, to bring them back to society. But in our state, if my lord would see a short note given on top of the record regarding Baleswar and Sundargarh, that would give my lord a small idea about what has happened and what the court had in mind when they had appointed us. So it's a short note.
It's been Bihari Pradhan versus state.
Between Bihari Pradhan versus state of Orissa. It is there. It says it on top of the case record. Short notes regarding leprosy colonies in the district of Sundargarh.
Short notes.
There is a bulky record. There is no. That can be given. It's also there.
So that starts from what?
That
What is
starts with order number 20 dated 14/7/2020. Serial number 8. So, the postmaster can just get that hard copy.
Order dated 24/9/2022 is there. All right, we will consider that aspect later.
I can have a look regarding the photographs, and that is what was first as a first brush across the state. If they can follow this template, I'm just giving my own copy. My lord, we see the. I'm sorry, my lord, just Raman. I'm just.
So it's
My lord, we see for Baleswar what was the status before all this happened and what they have transformed. This was the after court monitoring. So the idea in this PIL was to replicate this model so far as the basic necessities of these people is concerned. Then the question of integration would also come about. That Baleswar, they have been successfully been able to do it. Because what they did was they started this livelihood project. Like teaching and soft skills for driving, for mushroom farming, for weaving. The weaving unit was not working. So all that happened after a lot of nudging by the court. So now that Baleswar has been transformed, well, you might not see those photographs just towards the end. But we see from page 11 onwards of that note.
Yes, we can see.
So this is what happened. Now, this scenario exists in most, like in Sundargarh when we went, same situation.
Same situation means improved or same?
No, we have not been able to visit across the states. We have been able to identify some of them, and where it was really precarious, we have been able to bring it to the notice of it. So when the ground reality is this, when it is brought to the notice of the court, they bring into action. Then what my experience shows that if the collector is somebody who is sensitive, then things really improve well. That kind of sensitivity towards these people is something which they have to bring up.
So which are those places?
Now, across the state, there would be around like 180.
60, that's there, 60.
180.
80
Wait,
or-
186.
But we've covered, I think,
All such colonies are there. Now, we have been able to cover.
180 colonies recognized
yes, yes,
as
exist.
80.
180 colonies
880.
80.
Around
80.
eight, I'm not taking the exact.
All right.
86, Your Lordship.
86.
86 colonies recognized across the state.
Yes.
And can we have the district-wise
Yeah,
number?
that is also there on record. That's there on record. That list is there. A more full.
Now, to replicate this Baleswar model is something that this court had started off with. So for that, they have to make a lot of it. So then they have to really identify.
No, where is that? And this falls under which department?
Now, several departments are.
So several departments are involved now. Now,
Well, welfare department, there must be some
Health
nodal
and
department.
Family Welfare Department, even the Urban and Housing Department, the department which engages with livelihood. So all of them have now come together.
No, but there must be, or if there is none, then we should declare one department as the nodal department.
The nodal department is the Health Department.
Nodal,
Social security.
yes,
Department of persons with disability department.
you're right.
No, under that, but this meeting is being held.
No, they will have to apprise us.
Yes.
Yes, yes.
So we will not asking all the departments to inform. Rather, there shall be one department of the government who shall communicate to the
Yeah, it's the Department of Social Security and
SSEPD.
Empowerment.
SSCP department.
Social Security and
Empowerment of persons. With disabilities.
department. So who heads the department?
Social security
Principal Secretary.
and empowerment of persons with disability department.
Principal Secretary. All right. So we will take up the matter tomorrow,
May-
when the Principal Secretary of this department shall join.
They normally are there.
Hmm? Someone is there.
Normally they are there.
All right. So we will not ask the Principal Secretary to be a nodal officer, but we will ask him to appoint an active officer to be a nodal officer to coordinate amongst all the departments for the purpose of the present PI.
May I just bring another committee statement, order number 36, dated 25/4/2020. Order number 36,
Yes,
dated 25th of April 2020.
yes.
Wherein the department's name is there and the monitoring committee has been appointed by this court. That may not be on the scene.
No, monitoring committee has been appointed, all right. But the High Court, while dealing with these matters, should be informed by one person. That this is how that person shall be doing this for reporting to the court. All right, apart from Mr. Samantray, who is appearing, he will be assisting him, and there should be one person who should
But that is one of the problems that we are facing, so that can be. Now what we have actually discussed is Baleswar, they have been able to do a good job, but other areas they need to actually.
So that fellow will do. That fellow will run throughout the state.
Then we can look into the finer aspects of bringing them back with self on your own.
May I please, ma'am?
So
May I please?
we will act as super social security empowerment so and so department.
May I please, ma'am?
So the High Court becomes super department.
May I please, ma'am?
Yes.
My lord, I am for the petitioners, my lord. My lord, two things were submitted before your lordship, which is not factually correct, your lordship. My lord, the petition was primarily filed seeking the direction from this honorable court to provide the basic service that is required, as your lordship was saying, that why they couldn't be rehabilitated. Because the program that was launched by Government of India after devising a medicine to cure leprosy was exactly designed to prevent the disabilities that is caused by the attack of this bacteria and to rehabilitate them medically so that they can be fit for rehabilitation and integration in the society. My lord, in this state, from the very beginning, the entire program has been bossed up and leprosy is on the rise. And your lordship, the order number 20 that my friend Amiki Curies were referring to, your lordship may kindly refer to the paragraph 13 and 14, your lordship. This court was very much troubled by the development of leprosy and leprosy-related management, your lordship. And at paragraph 14, made specific direction, gave specific direction out of trouble that nothing is happening in this state, and the state must do something to ameliorate the condition of the patients, those who are suffering and those who are cured. Your lordship, they filed an affidavit in which this honorable court was not at all satisfied. Your lordship, after 20 hearings, that is order number 40, same order this honorable court passed again for the opposite parties that nothing has happened. And every time they have been putting evasive affidavits and misrepresenting the case. Your lordship, two sentences were said that leprosy is a skin disease and leprosy and the case is about leprosy colonies. Your lordship, all of us know leprosy is not a skin disease. It is a bacterial disease which affects the nerves and which causes loss of limbs and eyesight along with loss of sensitiveness. And your lordship, this case was filed to ensure the effective implementation of a national leprosy elimination program, not about leprosy colonies. It is only your lordship, this honorable court got disturbed by the developments and tried monitoring. For that reason, the team of amici curiae have been appointed. Your lordship, the state has filed two affidavits. All are evasive, pursuant to order number 20 and pursuant to order number 40, your lordship. With your lordships, with this court's permission, I had filed one additional affidavit bringing to the lordship's notice that all the problems that are persisting in this state from 2002, your lordship, in the name of curing, eliminating leprosy, what this state has done is that it has cured leprosy on paper. It is continuing, and your lordship, there are clear directions. Under government directions, the documents have been cleared of leprosy. Leprosy still exists in the field, your lordship. And your lordship, it was said that there are colonies and model colonies and facilities are there, looms are there. Your lordship, with the direction of this honorable court, I prepared a factual fact check in response to the affidavit filed by them. And I was directed to file the response. I seek your lordship's permission to file it. So
file it in the registry.
My
Let my lawyer friend also.
I'll have a copy on the document. My lord. So this, your lordship, once goes through this, it will be very clear that this case is not about leprosy colonies. There are leprosy colonies. My lord, if your lordship allows me 2 minutes time, I will just recapitulate.
So did the court observe that this is about leprosy colony only?
My friend,
Submitted. Yes, he
My lord.
submitted.
My
That is also a part.
My lord, that My lord, after it being artificially declared as eliminated, emerged as a public health concern from the year 2010, Your Lordship.
So, all right. What do you want?
There are many things to be done. The first thing,
First thing.
My
We
lord,
cannot, everything cannot be done.
My lord, exactly. The only prayer is that the leprosy people should be treated by trained people. There are provisions for employing people. They are not employing the people who would be treating this.
All right. The first aspect is.
That is the only aspect. That is what with the case.
It's not the only aspect.
Order number 40 is very clear.
My lord.
Order number 40.
My lord.
So it's a public litigation also because appointed 3 amicus curiae who are quite senior and they are also they visited this part.
No, that I have seen. It is there. Yes.
My lord, there are
Food, clothing and shelter.
Medical care.
And medical care.
Medical care.
These 4 aspects were focused now for the present.
My lord, in this state, there are 404 leprosy trained paramedical workers are provisioned. Your Lordship, out of that 321 are absent, are lying vacant. 320. In fact, more than that, right now, only 45 are on the field. Your Lordship, with the massive spread of, it is a public health concern because it has crossed the figure of 1 point.
No, where is that figure?
It's in the data. It's government data. It's government data that it has become a public health concern since 2011, 10 and 11.
No. How do you say that
My lord,
number of posts this much?
My lord, the WHO has put up a benchmark that if the prevalence.
Sir, we are putting a very simple question that where is that on record?
My lord.
That this much of posts are sanctioned and only this much of doctors are there. Where is that?
Not doctors, paramedical workers.
Paramedical workers. Where is that?
My lord, it is in the petition. It's in the petition that has been filed. The record is there. And my lord, there is noting that in.
Where is that? Please show.
That's what I'm showing. Annex page number 15, Your Lordship, may kindly see. Page number 15 of the paragraph of the petition, Your Lordship. The note sheet.
You know the note.
No note sheet of department you have enclosed.
Yes.
To the petition.
My lord.
202 is the page.
Where is there?
Page number 15 of the petition.
Yes. What is there? Please read.
My lord. It is for kind information that 321 posts of paramedical workers, leprosy, under NLEP, that is National Leprosy Elimination Program, are lying vacant in the state against sanctioned
posts. This is of 2013.
My lord.
What is the present position?
It has reduced right now, only 45 are existing. And the rest all are vacant.
Where? From where are you saying?
My lord, I have filed those documents and it is also in this. Once your Lordship gets it, we'll get to know. Everything is recorded on government record, all on government record, your Lordship. Even I have filed all those documents in my last additional.
Just a minute. Yes, what is the problem? That will have to be done.
No, something may say, but was the reapplication of public litigation or the purpose is for a different one, not for the benefit of those people. Now my friend is getting to the appointment and the.
Oh no. See, there. So all the aspects will have to be taken up together. When you are proceeding for the welfare of these kind of patients, then you will have to ensure that you have sufficient infrastructure, not only in terms of your the housing or something, but also for treatment.
So that will be taken care by the healthcare system and will provide whatever is required. Will definitely provide. That automatically falls to health and sanitation. This medical facility is also
this submission which you are making can be met in some other place like political hoga and.
Government has filed the affidavit.
All right.
Order number 33 make ITBC. Order number 30.
You are representing whom?
My lord, I am
All right. What do you want to say?
Order number 33 make ITBC.
What is there?
Although an affidavit dated 2nd December 2022 has been filed. Order number 33 dated 7/12/2020.
Yes.
Although an affidavit dated 2nd December 2022 has been filed in India stating 10,920 number of multi-purpose health workers and paramedical staff numbering 55,262 are also involved in case of detection, follow-up, and care, etc. It is not clear whether MPSWs are available for treating persons affected with leprosy, as indicated in para 4 of the court's order dated 14th November 2022. An affidavit has been tendered to the intervener in the court, wherein it is pointed out that in spite of sanctioned funds by the government of India for the purpose of engagement of 184 numbers of leprosy trained paramedical workers in 22 numbers of high endemic districts of Orissa, the funds appears to have been diverted for other purposes. Mr. Putuli learned additional government advocate states that a further affidavit will be filed specifically dealing with the issue of availability of trained medical staff as well as paramedical workers for providing treatment to the person affected by leprosy. The details regarding utilization of funds sanctioned by the government of India for financial year 2013 and 14 onwards for the purpose of providing the above treatment as well as training. We also
No, this is not the way how the proceedings should proceed, the PIL. My suggestion would be that let us have point-wise issues. Formulate 1, 2, 3, 4. And whenever the matter is taken up, we shall be addressing each of the points. All right. So that will be a kind of pro forma. And every time when we take up the matter, we shall see point-wise whether this has been done, that has been done. So you please do some exercise on that.
That's the reason why, Your Lordships, I was insisting that if this letter of those meetings are brought on affidavit, then Your Lordships will have an idea that what we are ventilating there and how the department, and what are the pointers.
All right. So you please also do, everyone of you do, see 7, 8, 9, 10 points, and those points shall be recorded. We shall prepare a pro forma rather. And every time when the matter is taken up, we will address 1, 2, 3, 4, 5, like that. Will that be?
Yes. That is why that order 40 very specifically that food, shelter, clothing, medical facilities, basic amenities. Then you may add this paramedical staff. Yes, that is what you can address each point. That would do.
Few things, in fact, the department now is doing, regularly ensuring cleaning of that place so that the hygiene is maintained. The normal paramedical facility is going there. Then they have started, in fact, many districts, like for example, we were talking about Baleswar, in Mayurbhanj, they've started to make those soft toys, which leprosy people can make, affected people can make. So all these things are being monitored. Now, in fact, they have also come, it took them also some time to come out with the exact pointers. So even places where, though there is no vegetation, but with the Kisam was jungle, so they're trying to change it. Because unless they don't change it, there are various facilities of the government which you really cannot implement. So I think once this report comes, on reading that report, we'll
let it come on Monday or Tuesday.
Tuesday.
2 o'clock Tuesday, Principal Secretary will join. Ask the Principal Secretary to appoint, to nominate a good officer, good experienced officer who can oversee the entire operation. All right. And then we can see.
Monday or
Tuesday at 2. It will not take much time. It should not. On Tuesday, we will take just 5 to 10 minutes. All right. After having heard one counsel appearing on behalf of the parties and the amicus curiae, it is deemed proper to adjourn this matter on Tuesday to be taken up at 2 p.m. Full stop. Considering the nature of the public's interest involved in the present writ application, we further deem it proper to direct presence of the Principal Secretary, Social Security and Empowerment of Persons with Disabilities Department. Disabilities. Persons with disability or disability?
Disabilities.
IES.
My lord.
Disabilities Department. Government of Odisha, online on the said date at the at 2 p.m. We'll stop. This matter on. We will see.
My lord.
And in the meanwhile, all of you, please do that exercise.
My
Like prepare a format.
lord.
And that format will be part of our order.
Obliged.
Item number 31.
I am there for the appeal.
Case
there is an
pending.
application for substitution is pending.
Who are you?
My lord, I am for the appellant. Appellant, my lord.
I'm for the legal error for respondent number 1 or 4 legal errors. There are 7 legal errors. We have initially filed the application for substitution on NLD 4. We have filed objection. Thereafter, we have filed the full substitution petition including all 7 legal errors. And I will appear for the 3 legal errors.
Let the substitution application be allowed and I may be permitted to file a cost title, my lord, consulted cost title and thereafter.
Another aspect also. My honored friend filed a petition for adducing additional evidence. Copy has not been served on me.
I will serve.
Lords, I am appearing for respondent number 2 and 3. I am appearing on VC minutes.
2 and 3.
2, 3.
Respondent number 2 and 3 minutes. There is a stay in this matter operating from 2017 minutes. We have also not been served with copies of the IA minutes. Copies may kindly be served before.
What is this matter about?
OLR case, my lord.
51D of the Oral Act. Odisha Land Act.
So one who is the appellant will have to address. Who is the appellant? Yes.
It's a case under OLR Act, my lord, relating to bhag tenancy, my lord. In the original court, the legal heirs of the respondent number 1 was declared as a bhag tenant. Thereafter, appeal was preferred. Against the appeal, revision was preferred. Thereafter, the matter was before this honorable court. The learned single judge has rejected the writ application.
You are challenging which order?
I am challenging, my lord, the order under annexure.
So why should we maintain it?
My lord.
Lords.
My lord, the substitution, my lord, unless it is substitution is allowed, my lord.
Substitution, we should not. This you are challenging an order dated 3/7/2017.
Yes, my
lord. So,
Lords and respondent number
17. That was an application filed under Order 41, Rule 10.
That along with the final order,
My final order is passed.
Both the orders were. There was an application for additional evidence was filed, and the learned single judge rejecting the application to lead additional evidence disposed of the writ application as well, my lord.
Milords, may kindly see
This
the
is the writ
reasoning
application as well.
accorded by the learned honorable single judge, Milords, in the writ order, Milords.
Prayer. Mr.
My lord,
We have prayer.
prayer, my lord.
This case number 195 of 2017, the judgment dated 3/7/2017. Passed in OJC number such and such. That is, that you have prayed to be, prayed for setting aside, right? Then, if you come to that order, which you have enclosed, 3/7/2017.
Yes,
You
ordered,
come to second page of that order.
yes, ma'am.
Such attempt cannot be entertained after long lapse of time, that too in the proceeding undertaken in exercise of power under Article 227 of the Constitution of India.
Yes,
So against the order passed in exercise of powers under Article 227 of the Constitution of India, writ appeal is not maintainable. That
My
is
lord,
what my lord
my lord,
is posing to you, then you have to address that question.
yes, my lord, I will address.
Yes.
This is a case, this is not a case where power under Article 227 is exercised. This is also a case where Article 226 is exercised. This is not against the order of any civil court.
The review before the learned single judge, not here. To correct this exercise of power.
I will satisfy your lordship and call it some other day. I will come with preparation. Since the substitution matter was.
Why substitution? Substitution, if we intend to pass any order against the opposite parties or the respondent, then the question of substitution or whatever will arise. If we are not satisfied with the merits of the appeal, why? Where is the question of
My
substitution?
lord, the writ appeal was admitted. Notice was issued to the
Yes,
opposite parties.
even then, we are here now. We are hearing.
We are questioning our jurisdiction to
Yes,
ascertain.
your lordship will fix a date. I will come prepared.
This is clear. This cannot be entertained.
Correct, Milord.
Such attempt cannot be entertained after long lapse of time, that too in a proceeding undertaken in excess of Article 227. Consequently, so and so is stand dismissed for being not entertained after such long time.
And
I will satisfy, my lord. I will satisfy, my lord.
some interlocutory application filing for additional evidence.
Addition, that application is there. That was there, my lord. Your lordship may call it some other day. I will satisfy.
And
Tomorrow.
appeal.
Tomorrow you will take unnecessary.
My lord, in a similar case, my lord.
No, this is of 2017. We are struggling with unnecessary cases pending here.
The issue is of 1987, Milords, been dragged on till 2017 when they received the order.
But there are
And the
decisions,
stay
my
order.
lord.
We'll hear you tomorrow.
My lord, I have not
No,
come
sorry.
prepared, my lord. Lordship may
Sorry.
sometime.
Sorry.
Monday, your lordship may call it Monday or.
All right, Monday. As requested, Monday.
32.
Great, Milord.
Yeah, interim order is there, it may be extended.
So you are having interim order
Yes, sir.
and therefore adjournment.
Milord,
No, my lord, not in that
Milord,
way, my lord. Not for that, my
since
lord. I will come prepared.
2017.
Interim order stands vacated. You have vacated the interim order.
Item
Grateful.
32. On behalf of Mr. Misra, is it
We
honestly?
have vacated the interim order, Mr. Counsel.
We're grateful, Milord.
We have vacated the interim order
Lordship,
because you are
till
seeking.
Monday, my lord. Till Monday, your lordship. Continue.
So interim order shall continue. The topic is made clear that if any adjournment is sought on behalf of the appellant, the interim order, which is continuing since
2017, Milords.
2017.
2017.
Yes.
32.
Highly
7, 12,
grateful.
22.
20.
I think this interim order is not continuing after 12/4/2023.
12/4/2024. Last
Thereafter, it is not continuing.
Last date, my lord. Last date, my lord.
Yes.
Then it's over.
4/4/2024. You have not paid for extension of interim order.
Yes, next.
Then 9/4/2024, it is not extended.
After it was.
Two dates, it has not been extended.
All right, feel happy. Yes,
32.
Item 32, I've taken up tomorrow.
bye.
Mr. Misra is on his legs and is arguing
Or
matter.
tomorrow.
Item 33.
May I please, Lordship, Lordship, allow on behalf of the petitioner, Lordship, I'm submitting. Your Lordship, there is a status quo in pertaining to the bond demolished under the Asildar. Lordship, allow on behalf of the petitioner, Lordship, I'm submitting. Your Lordship, there is a status quo in pertaining to the bond demolished under the Asildar. The order dated 23rd September 2021.
Therefore, to Monday at 2 p.m. it will be more convenient for everybody. And
Lordship, that will be Monday at 2 p.m.
The drone issue.
Yes.
Drone issue is.
Yes, ma'am.
Enter Tilika, Lordship, that what land issues.
Or Tuesday 2 p.m. Any
Monday ho, Monday.
Monday ho.
As jointly requested on behalf of the parties, let's just put her on Tuesday. Monday to be taken away at 2 p.m.
At 2 p.m.
Most obliged, Lordship.
Item number 34.
I am for the respondent number 5. Your Lordship directed the State Council to file an affidavit pursuant to your Lordship's direction dated 29th of February 2024. Here is the case is the respondent number 5 was appointed as a peer. His service was terminated
And
as a peer.
Peer.
His service was terminated. He had filed a writ application before this honorable court. The writ application was allowed with a direction. He will be reinstated and he will get 75% arrear. Only back wages. When the writ appeal was filed by the management, it has admitted only on the condition who will pay 75%. But in respect of the reinstatement, the writ appeal has confirmed. Now, your Lordship on 29/2/2024 directed the director to take a decision whether the government will pay or the management will pay that 75%. Now, the state is filing an affidavit and decided that the management now is not in a position to pay. The petitioner has not worked. Therefore, he may be reinstated. The amount may be waived. As if he is sitting, director is sitting over the order of this honorable court. When this honorable court has determined, I am entitled to get the 75% of back wages in 2018. From 2018 till 2024, they did not allow the respondent number 5 to join. And now, at the intervention of this honorable court, he was allowed to join. And the report of the Director of Secondary Education, if I will take your Lordship to the order, Annexure A/2, filed by the affidavit, the Honorable High Court of Orissa in operative portion of the interim order dated 29/2/2024 passed in WA number so filed by the Managing Committee, Anchalika High School, Kega, State of Orissa and others have directed as follows. The Managing Committee of Anchalika High School, Kega, at post Kega in the district of Palahandi and the land
You are
additional.
for whom?
I am for the peon. Who will get the benefit?
Who is for the appellant?
I am for the appellant.
So you have started arguing.
No, I have just brought to the notice of your Lordship. This is the development.
All right.
My lord,
regarding that it is an aided school, my lord. The government is bear to the back wages. Government is to bear the back wages.
You are challenging an order.
Order.
Let us see.
Where, my lord?
Let us see the order.
Mr. Mahanti, delay has not been condoned.
Order?
Delay has not yet been condoned.
No, delay has not yet been condoned, my lord.
But matter
No,
has
only
been
1
proceeded.
second, my lord, I'm thinking.
Matter.
Oh,
You are not pressed for that. You have never pressed your petition.
Your lordship, kindly come to this. My lord, your lordship, kindly come to page 37 of the brief.
No, your appeal is barred by limitation.
Yes, my lord, I have filed the petition for condonation
Mr.
of it.
Samal, have you filed any objection to that?
No, man. No objection.
You don't have. No, you won't file.
I have no objection.
No, you have no objection.
Maybe first. No, your lordship,
You don't have any objection.
No. I have no objection for.
26/10/2022, my lord, that
I have
it
been
was
disposed.
admitted. Appeal was issued notice in the matter. The lordship.
No, which IA is that?
493 of 2018.
18.
Flag B.
Lordship, may kindly have a
As
blank.
per your calculation, it is 74 days, but our SR has pointed out 92 days.
Yes, we are condoning the delay.
Pardon?
We are condoning the delay for
Oblige.
IA number 493 of 2018. The present appeal, intra-court appeal is bound by limitation. First off, there is delay of 74 days.
According to me, but staff reporter has stated that 94 days.
74 days, 92 days in preparing the present appeal. Stop. Considering the amendments made in this application, the delay in preferring the appeal stands condoned. Yes, it has come for admission or what? Order.
Come for admission.
For admission.
Admission. Is noted there. Yes.
My lord, your lordship kind come to page 37, my lord. Impugned orders, last portion, operative portion of the impugned
Which
order.
annexure? Which annexure?
That is annexure, my lord, 9. No, annexure. That part has been complied with. But however, considering that the petitioner has not worked all through, and this court interferes in the discontinuance order after 18 years, this court directs the school authority to release at least 75% of back wages and other benefits to which he is entitled to within a period of 2 months from the date of communication of the certified copy of this order. But this is an aided educational institution. The service of that employee was approved by the competent authority. He was getting salary from the government, my lord. And there, as the managing committee was constituted during that period, the management was vested under the statute with the district education officer, my lord. There is no source of income of the managing committee to manage the school, only the government, as he was an
Can that be a ground to assail the order?
My lord, that school authority and educational authority, they are 2 words, my lord. School authority means managing committee. Managing committee cannot pay, my lord, because he is an employee of an aided educational institution, only government is to pay, my lord.
Therefore, this appeal is not against him. This appeal, according to you, is against the government.
Against the, my lord, according to the government is to pay. That is to modify this portion of order is to, my lord, to be set aside. You will also direct the government to pay.
Manning income
So-
has no source.
Mister, you are not disputing the fact that he is entitled to 75%.
No, I am not disputing it.
So you are not disputing,
Yes,
then you are disputing that you are not liable.
I am not
The
liable.
estate is liable.
State is
So
liable.
this is a fight between you and the estate.
State, that I have implemented state as
So
party.
you could have filed a review, you could have sought modification of the order. There is no illegality in the order.
No, there is no illegality, only that it has been directed to school authority to pay mileage.
Right.
School authority is not liable to pay because he is an aided educational employee, institution of an aided educational institution.
All right.
Only government is to pay mileage. Your lordship kindly modify to that.
No, we are not here to modify the orders. We are here to see the legality. And that too in exceptional cases. Not in run-of-the-mill cases.
By that, my lord, the order
Yes, what is the stand of the state?
He was appointed by the private management against a non-existing post. When it came to the notice of the government, he has been appointed against a fourth post, though there is no fourth post of peer. Accordingly, government directed, though initially it was approved, government directed those posts, that there was no post of fourth peer. So these approvals shall be recalled. Accordingly, his post was, that approval was recalled. Your Honorable Single Judge.
As per yardstick, 3 peons
Yes,
are
ma'am.
allowed.
Yeah, 3 peons are allowed, but he was
This
appointed
is
against.
fourth peon.
Yes, fourth peon. And I will draw my lord's notice, my lord, on last occasion, your lordship had directed me. Lordship, my lord's direction.
Yes.
I have filed an affidavit, your lordship can see my affidavit. That was filed on 23/4/2024.
Yes,
Lordship got it, my affidavit 23/4/2024.
yes.
There, your lordship had order dated 29/2/2020.
No, it is not there.
I filed it on 23/4/2024.
23/4.
My lord.
It cannot be there. So what is there in that affidavit?
Yes, ma'am. In that affidavit, I have stated that your lordship may kindly ship my lord's order 29/2/2024, my lord's order.
That we have seen.
My lord's director, the managing committee of Anchalik High School, Kegaon, post Kegaon in the district of Kolahandi and the land and additional government are appearing for the state have raised dispute as to whether the governing body or the state shall pay to the read petitioner salary for the period during which he remained out of service in the light of the order dated 6/2/2020. That is 28, that was wrongly written, passed by the London single judge. In the facts and circumstances of we direct the Director Secretary of Odisha to take a decision in this regard after giving the managing committee an opportunity of hearing and inform this court within 3 weeks from today. In compliance to my lord's direction, the director has given that opportunity to the managing committee and also to that peon also. And passed an order on 22/4/2024 settling the issue between the management and that peon. And that order I annexed to my affidavit. If your lordship will go through by that affidavit.
Now what is there?
There, my management said before the director that they cannot pay because they are running with the financial costs. So after 1994, as the school has been taken over, as the school has been come to the granting court, and the payment has been made by the government, so they cannot pay. There, that person has agreed to that all the service benefit from the date of approval will be extended to him, except salary. All the service benefit and he will be included that pension, everything has been extended to him. Because he has not worked, for that reason he has not been paid. And service benefit, increment, everything has been granted, but notionally.
So he has agreed to that.
Yes, he has agreed to that. And he appeared before that director, he and the management, representative of management appeared before the director and the director has passed that order. My lord, I have annexed that order to my affidavit.
He agreed to that, my lord.
He agreed to that, then why is he raising dispute?
Your lordship kindly.
If my lord, that hard copy is with me, my lord, may submit, my lord.
Yes, we are disposing it off.
Lordship, I am taking to your lordship that order, page 4. OP number 5, the recent, just now I have received this copy. That the OP number 5, the writ appeal, Haladhar Sahu, who was the petitioner in OJS number, had 2 principal functionaries of the MC in the presence of government authority. He stated that he has hardly another 14 months for superannuation. His concern is more about life after retirement than present arrear claims. he agreed with the version of the MC that he did not work in the school from 2000 to 2024. It was because of sympathetic consideration by the Honorable High Court, he got back his lost service. He will be satisfied if authorities can make provision for his pension instead of arrear dues. He also submitted a written statement to the effect. A poor man hungry since 2000, not getting his salary, and abruptly has been terminated. He was earlier getting the salary. Person belonging to Kalahandi, the worst affected district of the state. He has no option except to agree. It is forced on.
We have limited scope in the present
My
procedure.
lord.
He has challenged the order.
Yes.
We are not inclined to interfere with on the grounds which have been taken. He can file a review application. He may file a review application. We don't. Now, in the meanwhile, something has been done. If you don't accept that, don't
No,
accept.
your lordship,
You can file
I would like to approach your lordship's concerns. At least from the date when this honorable court passed the order, he could have been reinstated. At least from that date till reinstatement, that salary may be paid by the
Who will
government.
give you?
Government will pay.
All right, you
Oh,
do that. You file
Again,
a
he is a
contempt-
poor man. He is on the
you
street.
file a contempt application.
Because of the pendency of this.
Mister, this writ appeal is pending. We are deciding this.
Oblige, your lordship.
He has agreed, my lord, I am placing the last paragraph. Nevertheless, in consideration of written submissions of Sri Haladar Sahu and in compliance with
You
the
fight outside the court. The present inter-court appeal has been filed against an order dated 6/2/2018, passed in OJC number 11774 of 2000. The appellant is the managing committee of Andaika Anchalika High School.
Kegaon.
Kegaon.
Kegaon. Kegaon in the district of Kalahandi. Stop. Respondent number 5
Respondent number 5
had filed the writ petition assailing an order dated. What was the order?
Order dated, my lord, Annex 2. Order dated 6/2/2018.
6/2/2018, whereby it was intimated to him, later dated, intimated to him that his service was no more required. Stop.
That is the letter, sorry to interrupt. That is the letter dated 24/10/2000 at page 34 of the brief. Letter dated 24/10/2000, page 34 of the brief. By that letter, he was prohibited.
File a writ petition for selling a communication dated
24/10/2000
24/10/2000, whereby he was informed by the appellant that his service as peon in the school was no more required. Stop. It was his case before the learned single judge that he was appointed against as fourth peon in Anchalika High School, Kegaon, which was established in the year 1986. Stop. Learned single judge allowing the writ application directed a reinstatement of the said respondent number 5.
Yes.
So respondent number 5 with a further direction to payment of direction to the school authority, that is opposite party number 4, to pay the 75% of the back wages for the period during which respondent number 5 had remained out of service. So stop. Next. Assailing the impugned order, Learned Counsel appearing on behalf of the appellant has submitted that the Learned Court and single judge wrongly directed the school authority to pay the amount. Rather, the state government had the liability to pay the amount. Stop. He has, however, not disputed the petitioner's entitlement to get 75% of his back wages. Stop. Next. Apparently thus, the appellant has not questioned the legality of the impugned order. First off, the appellant is more concerned with liability as to who will pay the amount of back wages. First off, in our opinion, this appeal is misconceived and is accordingly dismissed. The appellant, the appellant could have, it will however be open to the appellant to prefer a review application seeking modification of the impugned order. First off. Next, before we part with the present order, we must notice the fact that when the matter was taken up on 29/2/2024, the principal secretary,
Director.
the director,
Secondary education.
Director Secondary Education, Government of Odisha, was asked to examine as to whether the school, as to who was required to pay.
Yes.
As regards to examine as to whether the government or the school was required to pay the said amount of the back wages. Stop. An affidavit has been filed on behalf of the director, higher education, secondary education department, from which it appears that the director higher education had given an opportunity of hearing to the school as well as respondent number 5. Whereafter an order has been passed, taking into account the stand taken on behalf of respondent number 5. Stop. Next, learned counsel appearing on behalf of respondent number 5 has submitted that respondent number 5 had no other option but to agree to the offer made by the school, by the appellant and the estate. So stop. Next, be that as it may, we refrain ourselves from making any comment in that regard. So stop. This writ appeal is accordingly dismissed. With the observation as noted of.
I mean, stay my lord, your lordship giving me some time to file. Huh?
School authority. School authority.
Only time period limited may be fixed, I will file the review petition.
No, so it not.
Then limitation will may come.
May condone.
No,
Can you
no,
do that?
your lordship.
Had you been judge, you would have.
No, no,
condoned.
your lordship can give you some time frame to
Sir,
file the.
please understand. How can you make this prayer?
And only pray that time limit.
Can we
No,
condone the delay?
No, my your lordship.
Delay has to be condoned, even the
As concerned of.
if the circle officer has to condone the delay, he will condone the delay. The court will not direct him to condone the delay.
Okay.